Are we ready?
Morning, Judge. We're ready.
Can I have all defendants please stand and raise their right hands?
Los acusados todos, por favor, pónganse de pie, levanten sus manos derechas.
Do you swear or affirm the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? I do.
Juran solemnemente que el testimonio que ustedes van a rendir hoy será la verdad y únicamente la verdad. Digan que sí, si acaso es cierto.
You know, they just told me about that. Good morning, everyone. I'm Judge Natalie Moore. I'll be hearing your case today. When we call your case, you'll know that you're here and we'll address your individual case. For purposes of today's hearing, I'm going to provisionally appoint the public defender on all cases. Madam Clerk, do you want me to call the case? You do.
Su señoría le está indicando que ella le va a designar el bufete de abogados de oficio que le represente, aunque sea para esta vista, en todos los casos.
All right. State the public defender announces for the record.
Yes, Your Honor. Good morning. I say Karen O'Meara on behalf of the state.
Good morning, Judge. This is the public defender.
All right. First case I have is Wayne, Pickney, and Dylan.
Your Honor, the sound is going a bit in and out.
Yeah, we're having some trouble here too. We're gonna do our best. If you don't understand something, let me know. Mr. Dylan, do you speak English?
Yes, ma'am.
All right. Any arguments as to probable cause?
Not at all, Judge.
All right. Find probable cause, state you wish to be heard on bond.
Your Honor, he be asking for $500 bond.
Defense,
I'm sorry, I can't. What was that?
state asks for a $500 bond.
Okay.
Defense,
No objection.
all right. For bond in the amount of $500, what's the victim's name? The alleged victim's name?
It is going to be Tynesha Lee.
All right. Sir, I'm going to order that at this time you stay away from the alleged victim, TL. Do you know who that is?
No, I don't know who that is. I've been locked up 6 months. I don't know where they come from. That's why I'm couldn't get my dad. That's why I'm trying to find out.
All right. Sir, you have a lawyer who's going to represent you. You probably don't want to talk about the facts of your case because anything you say could be used against you. So you should let your lawyer do the talking. There's an alleged victim in this case, TL. If you're released from custody and you post bond, I'm going to order that you stay away from that person. You cannot engage in any criminal activity, use or possess any illegal drugs, or possess or have a contact or have in your possession a firearm or other ammunition. You are not allowed to have contact with the alleged victim, TL, in this case. That you can't speak to that person, go visit them. You can't have somebody else contact them. Do you understand all of my instructions?
Yes, ma'am. Sam, but this case happened to me. I was locked up when this case happened.
Judge, if I may, can I ask the state if they have dates when he was incarcerated? He's saying that he was locked up in May.
We would need to take a moment to see.
He's been in custody since June 2nd. Okay.
All right. The allegations in this case are from 27. All right. Thank you all very much.
Okay, thank you, Judge.
Next case I have is Jihado Spiruli. Do you speak English?
¿Habla inglés?
En 1606, los franceses se comenzaron a establecer.
Good morning, sir. Do you speak English?
Yes, ma'am.
All right. Any arguments as to probable cause?
Not at the.
All right. I'm going to find probable cause. Any arguments as to bond, state?
Yes, Your Honor. State believes that its standard is usually around 1,000. We would just ask for standard.
I'm sorry?
State believes that standard is usually around And for batteries, we can ask for standard.
Defense?
Judge, I don't think that he has any priors. We asked him for a reduced bond of $500.
All right, I'm gonna order a $500 bond in this case. I'm also gonna issue a stay away order. Sir, do you know who the alleged victim in this case, SC is?
Yes, that's my thing.
All right,
Your
I'm
Honor,
gonna order,
if I may, so you know the full name is on the second page of the state order.
all right. I'm going to order as follows, sir, that you stay away from SC. I'm gonna order that you cannot engage in any criminal activity, you cannot possess or use any illegal drugs, you cannot use, possess, purchase, or otherwise have contact with a firearm, weapon, or other ammunition. You understand?
Yes.
Before you were incarcerated, did you live with SC?
No.
All right. Please make sure that you have no contact with this person. I'm going to order that you cannot communicate with that person in any way, by email, text message, phone call, or in person. You cannot have any other parties contact SC on your behalf. Do you understand all of my instructions?
Yes.
All right. Thank you very much. Have a good morning. Next, I have Jason Rojas. Are you Mr. Rojas? You speak English? All right, good morning. Anybody have any arguments to probable cause?
Not at this.
All right, I'll find probable cause, state you wish to be heard as to bond,
Yes, Your Honor, so we'll be asking for standard $1,000 bond.
defense.
Judge, based on the prior, I see that he has no prior convictions. So we'd be asking for a reduced bond of $500.
And he does have an open case.
I'm sorry?
He has an open case right now.
There's an open case now
Yes, he has open drug possession.
on what type of release?
We can, looks like it's set for arraignment on January 8th.
All right, he's gonna be held on that case, is that correct?
One moment.
Yeah,
And for correction, the case number is B52587. I'm sorry, Steve, we can barely hear you.
Sorry, I think the microphone, it keeps going in and out.
yeah, both microphones are going in and out. I hear it. I know we're all doing the best we can today.
The case number that I think Ms. Omeda is referring is B2525887.
Yes, Your Honor, it appears it was originally a felony and it was bound down, so now it's pending arraignment and was released.
Okay, it's gonna be a case. I'm gonna issue a $1,000 bond and a stay away order on this case. Sir, do you know who the alleged victim DM is?
Chucking PM.
1 second.
Honor, just to be clear, he does not have a felony hold. There is no hold. He does not have a felony hold. We stated earlier that he might be being held for a felony, but that felony was reduced, so he was released on that other open case.
Right, but is he gonna be held on that case because he was released on bond?
That's, I believe, that the time to between, just to revoke or modify that one.
Yes, but
Okay. And since he's not gonna be held, I'm gonna reevaluate my prior decision. The bond in this case is gonna be $2,500 with the stay away order. That other case will be addressed separately. Sir, my question to you was, do you know who the alleged victim DM is?
She said, you know, this.
All right. I'm gonna order that if you are released and you leave custody, you are not to engage in any criminal activity, use or possess any illegal drugs, use or possess any type of firearm, weapon, or ammunition. Understand? I'm gonna order that you stay away from the alleged victim DM. That means you can't mail, email, text message, call, or have another person call, or have any direct contact with that person yourself. Do you understand? Prior to the incarceration, did you live in the same home as DM?
Did you live in the home as the
I'm sorry, you'll try again? I'm sorry, I'm gonna need someone to repeat that.
The sound is really weird.
Yeah,
DM lives in a house and he lives in an efficiency.
okay. Right now, you will not be allowed to go back to that property except in the presence of a police officer who will help you collect your things. You may not go back to the property without the police officer, and that will only be one time. So please make sure you make those arrangements. Otherwise, you cannot have any contact or go near the home. Do you understand all of my instructions?
Yes, sir.
All right. Thank you all very much.
25,500.
2,500 plus the stay order. Then I have Really, Eugene?
Repeat yourself because the sound is going in and out over here, so it is a little hard to hear some of the things you're saying.
I apologize. I appreciate you letting me know when you can. I know Sites is trying to fix the sound. We don't know what we're doing wrong. All right, Willie Eugene. Good morning, sir. Do you speak English?
I do.
All right. Any arguments as to probable cause defense?
Not at this time, Judge.
All right, I'll find probable cause stated to bond.
State would be asking for standard 1,000.
Defense?
No objection.
All right, I'll find probable cause. I'll issue a bond in the amount of $1,000 plus I'm gonna order a stay away order. Sir, do you know who the alleged victim CF is?
Come again?
Do you know who the victim CF is?
Yeah.
Do you know who that is? All right, I'm gonna order that if you are released from custody, that you do not engage in any criminal activity, that you do not use or possess any illegal drugs, and that you do not use or possess or have anywhere near you a weapon, firearm, or ammunition. Do you understand my instructions?
Yeah.
You are not allowed to have any contact with CF, the alleged victim in this case. That means you can't call, text, email, write letters, send carrier pigeons, and you cannot go see that person. I also need to instruct that you cannot have anybody else contact that person on your behalf. Prior to your incarceration, did you live with CF? Prior to your incarceration, did you live with CF?
She's talking to me.
Before you were arrested, did you live in the same house as CF?
Yeah.
All right. I'm going to allow you to go back to the premises one time in the presence of a police officer to collect your things. Do not go back to the house without a police officer present. Make those arrangements. It's important that you follow all of my instructions. Do you understand?
By being armed?
No.
No, sir. I'm issuing $1,000 bond and a stay away order. Your lawyer can answer any questions for you.
All right.
It's very important to understand the terms of the stay away order. All right, sir, I need you to acknowledge that you've heard my instructions with regards to the stay away order and you understand.
Yeah.
All right, thank you very much. Morning.
Morning.
Juan Nerios.
Good morning.
Good morning.
No, it's you speaking.
All right, good morning, Mr. Nerios. Do you speak English?
Good morning. Yes.
Does either party wish to be heard?
He speaks English.
Right, does either party wish to be heard?
Not at this time.
No, Your Honor, it appears he was out on a $7,500 bench warrant, but being as he doesn't have any violent priors, $1,000 is fine with the state.
There's some notes here. It's appropriate to hold for the division judge. I'm looking at the history of, and I agree with that assessment. All right, so this case will be reset so that you can go back and see the division judge in just a few days. All right, sir?
Well, I just came from audio and the case got dropped.
Sir, you're welcome to speak with your lawyer about this case. You shouldn't directly address me, but I'm looking at the number of times there have been some failures to appear. I'm looking at the nature of the underlying charges and what's been going on in this case, and I'm going to send you to see the division judge. So that's what we're going to do today, okay?
Yeah.
All right.
William?
Madam,
I'm sorry, Your Honor. What was the bond for Ms. Nenarios?
there's not going to be a bond. He's being held for the division judge. Who can set
Your Honor, he still needs the bond.
Yeah, you'd be ready to call. Okay, give us 1 second. We're gonna be in recess for just a minute.
Recording stopped.
All right. Based on what the clerks have now provided for me, I'm now looking at this case separately. There isn't going to be a hold for the division judge.
Recording
I'm
in
looking at the
progress.
history of failures to appear and the history in this case. The benchmark, $5,000 is going to be converted to a $5,000 bond. I'm also going to issue a stay order in this case. Sir, do you know who the alleged victim AL is?
It should be my girlfriend.
I'm sorry?
Yes, it should be my girlfriend.
All right. I'm going to issue a stay order and an order as follows. Please listen carefully. If you are released from custody, you are not to engage in any criminal activity, use or possess any illegal drugs, use or possess a firearm, gun, weapon, or ammunition. Do you understand?
Yes, ma'am.
I'm also going to order that you stay away from the alleged victim AL in this case. Before you were incarcerated, did you live in the same home as AL?
I was there. Yes.
All right, I'll give you the opportunity to go back to the home 1 time in the presence of a police officer to collect your things. Other than that, you are to have no contact with AL. That means no phone calls, text messages, instant messaging, or any contact through social media, no contacts with third parties. Do you understand all of my instructions?
Yes, sir.
All right, thank you very much. Have a good morning. I didn't state it on my probable cause on the bench warrant. Dexter Small.
Present judge in English.
All right, thank you. Any arguments as to probable cause?
Not a
State heard as to bond?
I don't know. No, Your Honor, we can do $1,000 in it bond.
no objection.
All right, on probable cause. I'm gonna issue $1,000 bond plus a stay order. Sir, do you know who the alleged victim in this case is? The initials are MJ.
Yes, correct. ma'am.
All right, I'm gonna order as follows. You are released from custody. You are not to engage in any criminal activity, use or possess any illegal drugs, possess a firearm, weapon, or other ammunition. Do you understand?
Yes, yeah.
I'm also gonna order that you have no contact with the alleged victim, MJ. Before you were arrested, did you live in the same house as that person?
Yes, yeah.
All right, I'll give you the opportunity to go back to the house 1 time in the presence of a police officer to collect your things. Other than that, you are to have no contact, not go by the home. You can't have contact by email, phone, text messaging, social media, or have any third parties contact that person. Do you understand?
Yes, yeah.
All right, very much. Have a good morning.
To your
Hi, Gwen.
So judge, is my understanding that this next individual speaks Vietnamese?
I believe we were working on collecting a Vietnamese interpreter. Sites to that person yet?
No, Your Honor, not yet. I will need from corrections to give the Vietnamese interpreter is the misdemeanor number. They need that.
Case number?
Yes.
Case
M25 27444.
27.
444.
I can't hear because it's only 4 numbers, and I'm sure it's more.
Because I think her microphone's going out. M25 27444. So 3 4.
Okay, thank you very much.
All right, so we'll pass this case for the moment until we're able to get the interpreter present.
Okay, thank you.
And the name?
Then I have
Hoi Nguyen.
Okay,
Then I
let
have
them get that.
Mitchons.
Your Honor, the case is reset for Monday.
All right, so we'll be reset for Monday.
Yes,
so
Your
bad.
Honor.
All right. I think that's the last case we have until we get the interpreter. All right, we'll be recessed until we have access to the interpreter. Thank you all very much.
Recording stopped. Recording in progress.
Mr.
All right, let's go back on the record for a minute.
Your Honor, he already has
Sarah, will you
the
help us
the
find
Zoom
a
number.
Vietnamese interpreter?
He already has the case number too.
Mr. Martin, are you able to find an interpreter?
Yes, yes, and I gave him the case number, and he should be calling the 786-635-1003 Zoom phone number.
Okay,
All right, one more minute.
thank you, Judge.
Is anyone there? Can somebody ask him if he speaks either French or Mandarin? Because I could get him one of those easily. Okay.
We'll go on the record very quickly. In this case, no, I'm gonna finish this one. So this is our last case on the DD calendar, Mr. Quinn. I'm going to find probable cause and reset this case to 12/14 for bond determination. I'm gonna require that we have a Vietnamese interpreter here at 9:30 so we can begin that here in the first, okay?
Your Honor, unfortunately, we can't do that because they're not our employees. And I already tried with this guy. If he speaks Mandarin, which a lot of the Vietnamese do, or even French, we could have more of a pool. But we can't have you somebody here at 9:30 tomorrow. They can have somebody on Tuesday, but that would be too long.
All right,
I'm asking who else speaks Mandarin or French.
Only because there were a French colony many years ago, and so many people in northern Vietnam speak Mandarin. But
I'll make
that's
some
just
calls on
me.
my end to determine if we can get somebody interpreting here in Vietnamese.
Okay.
All right, we'll reset till tomorrow for now and I'll do what I can, okay?
Okay, thank you, Your Honor.
That we are to get an interpreter, and it's my understanding that he does not speak Mandarin.
All right,
Okay,
thank you very much.
okay.
All right, we'll go on the record in our misdemeanor count, is that correct?
Recording stopped.
Yes.
Take your time.
Your Honor, this is Joanne Hennessy. I'm
Recording
here for
in
the City of Miami
progress.
Beach for the jail
Sorry,
arraignment
There
calendar.
was a lot of noise, I didn't hear whoever that was.
Thanks. This is Joanne Hennessy. I'm here for the City of Miami Beach for the jail arraignment calendar.
All right, thank you very much.
Thank you.
All right, so we'll go on the record, this is our misdemeanor calendar. Do we swear everyone in or we're gonna handle these individually?
They've been sworn in already, Your Honor.
All right, and everyone has had opportunity to view the video this morning?
Yes, Your Honor.
All right, thank you. I'm gonna provisionally appoint the public defender in all cases.
Public defender accepts the
All right, get started. Case I have is out of turn. This is Stephen Thompson.
So, Judge, he refused, so we don't need to call him out his name.
All right. So,
Your Honor, he's set for tomorrow. He didn't want to wait. He went back.
all right, we'll reset that case to 12/14. Did I start? All right. Salon Soberats Rodriguez, is that you, ma'am? Do you speak English? All right, morning, ma'am. Any arguments to probable cause?
Your Honor, these are added charges.
Thank you.
Not a
Any arguments to probable cause?
this time, Judge.
All right, state you wish to be heard as to bond?
Yes, Your Honor, the defendant just recently had a petty theft from 2024 and a controlled substance possession from 2025, as they would be asking for an elevated bond of 500.
Defense?
They second degree misdemeanor, we would be asking for the court to issue a standard bond of $150.
All right, based on the history, I'm gonna issue a $500 bond and a stay away order. Ma'am, the place where you were arrested, a Publix on 112th Avenue, you know where that is? Yes, I do. I'm gonna order that you not go back to that property, do you understand? All right, if you go back to that property, you can be arrested for violating my order, please don't do that, okay? Thank you, ma'am, have a good morning. Cynthia Haynes. Ms. Haynes. Good morning, you speak English? Good morning. I'm sorry, I can't hear you, you got to speak into the microphone.
Yes, good morning. I speak English, ma'am.
Thank you. Does anybody have any argument as to probable cause? This is a bench warrant, correct?
Yes, ma'am.
State, do you wish to be heard as to bond?
State is fine with standard bond in this case, Your Honor.
Defense?
Judge, I only have bench warrant arrest form. What is the level of the charge?
Looks like the revocation was 500 on count 1 and 500 on count 2.
If I may, Your Honor, she also has an open felony.
Will there be a hold on the felony case actions?
No, Your Honor, the felony was addressed on yesterday. She received a total bond of $1,500. Her presence was waived on yesterday.
All right, I'm gonna issue a $500 bond on count one, $500 on count two. I'm also gonna require a stay away order from 219 Southwest 11th Avenue. Do you know where that is, ma'am?
Yo, second, address. I'm sorry, repeat the address again, please. I didn't hear that.
219 Southwest 11th Avenue. You know what that address is?
Is that the address where I was apprehended?
Yes, ma'am. The
Okay.
address where they're saying you were trespassing.
Okay.
I'm gonna order that you not go near that location, not go in that property. Do you understand my instruction?
Yes,
All right. All right, 500 on count one, 500 on count two with the stay away order. Thank you very much. Next case is Yuri Cortez Vasquez.
Your Honor, we set for tomorrow medical.
That case will be reset to 12/14. Isania Zapatunez.
Bonded out.
Shakina Nickerson.
Come on.
All right, it looks like this is an arrest on multiple bench warrants with some additional traffic citations. Is that correct?
yes, sir.
Any argument from the state?
Yes, Your Honor. The state of the act for elevated it appears that there are multiple bench warrants open, 10,000, 1,000, 1,000, 1,000. So they would be asking for elevated on all counts.
Defense?
Judge, we would have kept with the implement standard bond on all things of $150 and change.
Okay.
And Judge, unfortunately, Miss Vick is a student. She wouldn't be able to afford a bond of 1,000 each count. I believe this one count's got to be $4,000 bond. So we will be further asking for $150 each count.
It does also appear, Your Honor, that Ms. Dickerson has a 2022 guilty driving with license suspended and a 2024 controlled substance.
Judge, I'm sorry, I can't hear you.
I'm gonna issue $1,000 on each of the bench warrants. That's 1, 2, 3, 4 outstanding bench warrants. Is that correct? Corrections?
Yes, Your Honor.
And then I'm gonna issue a bond of $500 on the no valid driver's license, 500 driving without a state license, and 250 on count 7, the non-resident requirement violation.
I'm so Judge, the sound is
Your Honor, I'm sorry. Can you call the case numbers, please? Because she has a total of 7.
Yeah, go ahead, try again. Call the case numbers and I'll tell you.
The YQE is 1,000. The A5E is 1,000. The 2PE is 1,000. The 2QE is 1,000, correct?
Yes?
The Y1E is 500. The Y2E is 500. And the 60E is 500.
Correct. So that brings the total bond to 5,500. Is that correct, corrections?
I'm sorry, Your Honor. What did you say?
That came to a total of 5,500, correct?
I'm sorry.
I think that's the amount that I had. If we 1, 2, 3, 4, 1,000 and 1, 2, 3, 5, 5, 55.
Okay. All right, take care of that case. Yes, corrections?
Yes, Your Honor.
All right, very much. On all of them. All right, thank you. Next case is Tamajan Ibis.
Your Honor, she has an open felony. She'll be back on your bond hearing calendar.
All right. Do either of the parties be heard as to this case?
Yes, she does have a felony. Additionally, we would be asking for an elevated bond. I don't know if we want to readjust this when the felony comes up.
All right. Defense any arguments, probable cause or bond?
Your Honor, it's a related felony. She'll be back on your bond hearing calendar.
So you want me to just hear the whole thing then?
No, it has to be addressed on this calendar, the traffic case.
Okay, so any argument from the defense?
So just the traffic in the two people files will be addressed later on.
Yes, ma'am.
Okay. For the traffic, I would be asking for a $150 bond. I do assume that once her case is addressed later for the companies, there will be higher bond, but I think for count 5, which is the new valid driver's license, we'd be asking for 50. Driver's license.
Okay, I'm gonna step on to $250 on the traffic citation. We'll address the rest of felony bond. LaForest Levy. Any arguments to probable cause defense?
Not at this.
All right, good morning, ma'am. State in the arguments to probable cause.
Arguments as to probable cause.
I'm sorry.
Fine, Your Honor.
No objection.
Can I read it correctly that there's a bench warrant out on this case? So I need to send on the new case and a bench warrant? No.
There's supposed to be 2 bench warrants.
2 bench warrants.
Yes. Case number APLMAGE and AMDSU8E. We would be asking in those cases 500, 500, same amount as the bench warrant, and then in the case in front of us, standard 150 is fine.
All right, I'm issuing $500 bonds on all 3. If I didn't announce before, I did my probable cause on the new case there and 500 on each count. The next case I have is Maribel Ramirez.
Present. Excuse me. Yes, ma'am. She's
Pick up on a bench warrant. Defense, do you wish to be heard as to bond?
Just how, like, what was the bond of this bench warrant? I don't know.
1,500. It was a failure to appear for arraignment in front of Judge Alvarez.
Okay, because failure to appear at arraignment, we'd be asking for a standard bond. Do we know if the defendants were represented at the time she was arraigned? Yes.
I don't have that information.
What was the question?
I'm sorry, can you hear me well, Judge?
You're cutting in and out, but you asked if she was represented at arraignment?
By the public defenders.
I don't know.
Okay. Well, Judge, we would be asking to the $150 bond instead of the $1,500 bond because she failed to appear at arraignment. So we don't believe that the state was prejudiced at the time. Correct. And she was published to make up that she did not receive proper notice for her arraignment date.
Ma'am, you don't have a place to live right now?
I haven't now.
They,
No objection.
all right, we'll keep the bond at $1,500. Ma'am, do you have a place where you can receive regular notice now by mail?
Yes, ma'am.
All right. Make sure you show up for your next case, okay?
Judge, the bond is 1,500.
No, 150.
Okay, just okay.
Desmond Randolph,
Yes.
I'm sorry, y'all. In reference to Ms. Romanes, is it 150 or 1,500?
150.
Thank you.
I apologize if I said it wrong.
Judge, Ms. Randolph, speaks English.
All right, Mr. Randolph, do you speak English?
Yes.
All right. Argument is to probable cause defense.
Can you repeat that?
I'm asking your lawyer if she has any argument as to the probable cause, sir. She's going to represent you today, okay?
Your Honor, this is an added charge.
Defense?
Judge, not at this time.
All right, I'll find probable cause. State, do you wish to be heard as to bond?
Yes, Your Honor. The state would be asking for a bond of 1,500, being as there are multiple other open charges, another felony battery on a law enforcement officer. And he does have a few prior convictions.
Defense?
Judge, defense will be asking for standard bond in this case. I do think he was taken into custody on the felony, so he wouldn't be going anywhere anyways. We'll be asking for a standard bond of $500.
All right. After reviewing the affidavit, I'm going to issue a bond of $1,500. I've already found probable cause. Sir, if you can post that bond, we're going to see you on another case, okay?
What's the
All right. Ahmed Sagi. Thank you.
Judge, she's present and speaks English.
All right. Good morning, sir. Defense, any argument as to probable cause as to the first case, the one that ends in 260?
Not at this time.
What about it, the one that ends in 259?
Not at this time.
State, do you heard as to bond?
Yes, Your Honor. The state would be asking for an elevated bond of $1,000 on each count. The defendant currently has 5 other petty theft cases open.
Defense?
Judge, we would be asking for standard bond. Mr. Sagi is homeless. He would not be able to afford an elevated bond. An elevated bond would be equivalent to holding no bond. And we don't think that would be appropriate for this type of charge. We would be asking for standard bond.
Noting the number of open cases, I'm going to find probable cause, and based on those open cases, I'm going to issue a bond of $1,000 on each of the 2 cases. Yes, dear.
Your
I'm
Honor,
also sure that you stay away from the arrest locations. That's 1981 Northeast 135th Street. For a second. Do you understand my instructions, sir? You are not to go back to that property while you are out on bond. Do you understand?
Responding.
Your Honor, I'm sorry, this is corrections. That was 1,000 each count
Yes, ma'am.
case. Thank you.
And the stay away order. Do you understand, sir? I'm telling you that you cannot go back to 1981 Northeast 135th Street.
Yes, ma'am.
All right. All right, Michael Sherba.
Your Honor, this is an added charge and he refused court. This is his 3rd refusal.
State. Defense, do you want to waive the presence?
I don't think I can waive his presence for bond, so I would just ask for it to be reset.
All right, this will be reset. Can we just reset this to the jail division on Monday? All right, we can't do that. We'll reset till tomorrow, see if it comes. Ma'am, if you have any way of reaching your client and letting him know, a bond could be issued on it.
Okay, we'll do.
Jerome Tompkins. defense.
Who's speaking? Who's speaking? Okay, good morning. Judge and
All right, there's defense. Do you have any arguments for probable cause?
I don't have any probable cause arguments at this time.
State, do you wish to be heard as to bond?
Yes, Your Honor, the state would also, these are one of those cases that we would give an offer in if Your Honor wants to entertain such, but if not, we give a recommendation for bond.
I'm sorry, I didn't hear Ms. Salgado.
The state is saying they'd be open to a plea agreement. However, the court is reading this where it says a firearm for the defendant's waistband.
Then Your Honor, the state asked for $500 bond in this case.
I'm not willing to consider obtaining out more information, so we're not gonna do that today. I'm gonna find probable cause. Defense, do you wish to be heard as to the bond?
Judge, in response to the firearm, he's not charged with possessing a firearm. He's only charged with drug paraphernalia. I'd be asking for the bond in this.
All right, I'll issue a bond in the amount of $500. Zuko Stanislav.
Your Honor, Joanne Hennessy for the city of Miami Beach.
Thank you, ma'am.
Your Honor, can we pass them, please?
Yeah, we'll pass. Andy Rodriguez.
Your Honor, can we pass them, please?
You want to pass Rodriguez?
Yes, Your Honor. They're
No problem.
he's en route.
Brandon Twist. Good morning, sir. Do you speak English?
Judge, this is Mr. Stanislav.
Go back.
Joanne Hennessy for the city of Miami Beach.
All right. Mr. Stanislav, do you speak English?
What language?
Okay.
Judge, he,
What then you have my mother recommend English is of its preference, but
okay, so he is requesting, he's bringing an interpreter. He doesn't understand some English. So I guess I want to proceed, and if
Can you
All right,
ask him if
sir.
it's Russian or Ukrainian?
Ukraine.
Ukrainian, we could get one.
We can get an interpreter
Oh, yes, for sure.
today.
Right now.
All right, we're gonna pass this case until we get the interpreter. Corrections, can you bring it back in a few? All right, I'm still passing Brandon Twist, so that takes us to Giovanni Kermis.
Your Honor, I'm sorry, Mr. Andy Rodriguez is present now.
All right, we'll go to Mr. Rodriguez.
President, Judge.
Mr. Rodriguez, do you speak English?
Yes, sir.
All right. Defense, do you have any argument as to probable cause?
So, Judge, I would make a couple cause argument. In the arrest warrant, the defendant, it says that the defendant advised that he was advised that he would have to purchase tickets online plane. That's just untrue. You go to the airport and purchase tickets. So I do believe that it could be the argument could be made that he did have reason to be at the airport, therefore trespass would be invalid, so he has those online.
State?
Yes, Your Honor, just one moment. Yes, Your Honor, so although somebody can have a reason at being at the airport, he was trespassed and refused to leave after being warned as such. His behaviors at the airport is what led to the original asking of the officers for him to leave. So although a person can be present at an establishment or a public place such as an airport, the charge in front of us is a trespass and a trespass after a warning.
All right. I find that there is probable cause based on the allegations in the form. Either party wish to be heard as to bond?
Standard is fine, Your Honor. At this
Judge,
it's 500.
Defense?
Mr. Rodriguez does not have a conviction. In previous cases have all been dismissed. So we'd be asking for a reduced bond of $150.
Can you tell me if he lives here in the county and has an address?
Judge, he lives within Miami County.
And does he have a permanent address?
Not at this.
He does not have a permanent address. Can we give it?
Not at this, Judge.
All right, sir, I'm gonna release you on your own recognizance at this time. I'm going to set you for a hearing. If you fail to appear for that hearing, they will arrest you again, and at that point, you will have a bond issue. You understand? So it's very important you come back to court. Do you understand?
Yes, ma'am.
What's that? You're gonna be ordered to come back to court on January 9th at 9 a.m. in courtroom 5-1 here in the Gerstein Justice Building. Do you understand my instructions? I need you to answer me out loud, sir. If you don't understand, you can ask a question of your lawyer.
Yes, sir.
Okay, we just changed it. So the lawyer's gonna write it down for you. You need to appear in court on January 8th at 9:30 a.m. 9:30 a.m. in courtroom 5-1. Do you understand? You guys are muted, so I can't hear you. Madam Public Defender, I need to be able to hear your client answer.
Good.
You understand?
Yes. I understand.
All right. I'm going to release you on your own recognizance. Come back on January 8th at 9:30 a.m. to courtroom 5-1. Madam Public Defender, you're going to write down that information for him?
Yes, Judge.
Sir, if you fail to appear, you will be arrested again. Do you understand?
Yes.
All right. Have a good morning. Corrections, you want me to recall the other two or keep going forward?
Mr. Twist is here, Your Honor.
All right, we'll call Brandon Twist.
Your Honor, state is going to make an announcement in this case.
Go ahead.
Case number M25027423, state announced any no cross. I'm sorry.
Did you say F25?
M.
I'm sorry.
For
Your-
Mr. Twist.
Try again.
That case number?
M25-27423, state announced they no cross for prosecutorial discretion.
Thank you.
All right, so that case will stand dismissed by the state attorney. Sorry.
Your Honor, we have she should be calling in. Her first language is Russian, so her Ukrainian may be a little rusty. She only needs the misdemeanor case number.
Okay. Let me know when you're ready for it.
Okay.
B25 2417.
2417. I'm missing a number.
B25
Mhm.
27417.
Perfect. Got it. Thank you. She should be calling in. Her name is Helen.
Thank you.
Okay, so everybody's gonna keep an eye on that Zoom and wait until we see that call in. In the meantime. Is it any speed? All right, Giovanni Gomez, is that you, sir?
Yes,
I'm sorry, I can't hear you, sir.
yes, ma'am.
All right, do you speak English?
Yes, ma'am.
All right. Defense, any argument as to probable cause?
Not at this time.
State, do you wish to be heard as to bond?
Yes, Your Honor. The state would be asking for an elevated bond, being as in the last 3 years, the defendant has had 4 theft convictions, one of them being felony grand theft.
Defense?
So, Judge, we would be asking for the court to issue standard bonds in this case. That's what, Judge.
All right. I'm gonna issue bond of 250 on count 1 and 500 on count 2.
I'm sorry, Your Honor. Repeat.
$250 on count 1, $500 on count 2. I'm finding probable cause. I'm also gonna issue a stay away order, sir. The Publix on Northwest Second Avenue. Do you know what I'm referring to? I'm gonna order that you stay away from there. If you go back there, you'll be arrested for violating my order. Please don't do that, okay? Thank you, sir. Have a good morning. Maurice Benton. Are you Mr. Benton?
Yes, Judge. And after this, the interpreter is present, so we can call that case in this.
All right. You're Mr. Benton, yes?
Yes.
You speak English?
Yes.
All right. Defense, do you wish to be heard as to probable cause?
Not at this time, Judge.
State as to bond?
Yes, Your Honors, you would be asking for 500 on each count.
Defense?
Judge, Mr. Benson is homeless. We do believe the standard bond of this case of $500 bond would be equivalent to no bond. Due to the nature of the charges, we would be asking for dollar bonds on each count.
All right. Based on the number of arrests in the history here, I'm not gonna do that. I'll issue a bond of 250 on count 1, 250 on count 2. Sir, if you are released from custody and you bond out, I'm gonna order that you stay away from the Publix on Biscayne Boulevard, 1776 Biscayne Boulevard. Do you understand my instructions?
Yes.
If you don't bond out, you'll go before a judge on Tuesday, okay?
All right.
Your Honor, I'm sorry. What was the bond for count 1?
250 on count 1, 250 on count 2, plus the stay away order.
Thank you.
Yes.
All right, cites of our interpreter inside for Mr. Stanislav's case.
Again, Joanne Hennessy here for the city of Miami Beach.
Yes, ma'am.
Your Honor, Russian interpreter is present. Do you need Russian interpreter for this case?
My understanding is we need Ukrainian.
Oh, Ukrainian interpreter is not available, and I was told that he can speak either Russian or Ukrainian.
Ma'am, will you confirm with your client that he understands Russian?
Алло, здравствуйте, я переводчик. Вы по-русски понимаете?
Понимаю.
Yes,
Well-
I understand. Uh-huh.
All right. Sir, good morning. I'm Judge Natalie Moore. I'll be hearing your case.
С нами разговаривает судья Натали Корн, она будет рассматривать ваше дело.
I've appointed a public defender to represent you.
Я назначила общественного адвоката, чтобы вас представлять в этом деле.
If I may, Judge, he does not speak Russian, he speaks Ukrainian.
I understand, but he did say he understood what she was interpreting.
I understand, but I don't speak.
Okay. What I can do, sir, is I can leave you in custody. Ma'am, if you could interpret, you can stay in custody and I can try to get another interpreter.
Если вы хотите, сэр, я могу вас оставить в заключении, и мы пока будем искать украинского переводчика.
Or I can address your case with you now between the English and the Russian if you understand.
Или я могу сейчас рассмотреть ваше дело, будет английский и русский язык, если вы понимаете.
Judge, he would prefer to just proceed in English if we cannot find a Ukrainian interpreter.
Okay.
Thank you.
Sir, we're going to go slow so that you understand everything. So far, you understand?
Yes.
All right. Defense, any argument as to probable
You
cause?
take over.
Judge, I don't have any probable arguments at this time.
All right. Going to find, sir, that there's probable cause that the officers had the right to arrest you. Does the county prosecutor want to be heard as to bond?
Yeah, I'd request standard bond in this case. Mr. Stanislav has an out-of-state address. I'm not sure about any local priors. I don't show any, so I have unknown priors, but I'm not sure about out-of-state priors. So I'd ask for standard bond in this case.
What's the standard bond on this?
150.
Defense, wish to be heard.
Your Honor, interpret?
No, she's not interpreting. We're proceeding in English.
So, Judge, at this time, we would be asking for him to be released on his own recognizance. He has no priors to the nature of the charge. We don't think that keeping him in custody would be appropriate. He cannot afford a $150 bond. It's our position that that would be equivalent to holding him no bond. And he would be able to make it to court, even though, like, Zoom court still.
Do you have any information to provide the court with regards to your client's address, where he resides?
One moment. Judge, he does live in Nevada. However, he did assure me that he would be able to attend for the hearing. And if a trial were to be had, he knows that he needs to come in person.
Mr. Hennessy, anything further?
Nothing, Your Honor.
All right, I'm going to release the defendant on his own recognizance. Sir, you are still going to have to appear in court, but I'm going to let you go. You understand?
Yes.
You understand that you need to appear in court for your next hearing.
Yes, you're not allowed to be in court.
You need to provide the public defender with your address so that we know how to reach you wherever you are, okay?
And you're.
All right.
Judge,
Okay.
do we have information of his next court date so I can give him a date certain for him?
You said he was returning to Nevada. Is he staying in Miami?
No, the address is Nevada. He did say he lives in Nevada, so if that's okay, no problem.
Your Honor, I'm sorry, this is your interpreter speaking. What's the last name of the defendant?
Okay, let's change it up. What date can we have him back in court if we give him a date? Sir, listen to me. Will you still be in Florida in January?
No, but if you come to Florida, I can do so. I can hear.
Miss Hennessy?
I'm sorry, I didn't understand what he said, Your Honor.
I think he's saying he doesn't anticipate being in Florida in January.
Judge, he did let me know that he would come for court if he needs to, and I do have.
Do you want him to fly back to court, Miss Hennessy?
Your Honor, I'm not sure how that's my decision to make. I'd ask for standard bond. I'll defer to you regarding the release conditions. I'm not.
Okay, I'm gonna release on his own recognizance. You'll get notice in the mail. You need to make sure you provide your address, okay?
Thank you, Judge.
All right, Blue Lance Bond. And Madam Interpreter, you're free to go. Thank you very much for your assistance.
Yes, thank you very much, Your Honor. And what's the last name of the defendant? Stanislav is his first name. And what's the last name?
Is last name is Stanislav.
I'm sorry?
Zubkov.
Zubkov. Yes, got you. Thank you. Have a nice day. Goodbye.
Blue Lance Bond. Just
wonderful.
All right. Good morning, sir. Do you speak English?
No.
Yes. All right. Defense, any arguments as to probable cause?
Not every.
Sir, I'm having trouble hearing you, but you have a very good attorney representing you, and anything you say can be used against you, so you should talk to her and then let her tell me what she wants me to know, okay? So talk to your lawyer, tell her what your concern is. In the meantime, State, do you have any arguments to bond?
No, Your Honor, his priors are fairly remote, so standard bond is fine with the state.
Standard bond is 500?
Yes.
Defense, any arguments to bond?
Judge, we would be asking for Mr. Pond to be released on recognizance. He is homeless. So he would not be able to afford a $500 bond. 500 for homelessness would be equivalent to no bond. So we have to review it.
All right. I'm not gonna ROR this time. Find probable cause. I'm gonna issue a $500 bond and stay away order, sir. If you are released, you will not be able to go back to the address where that you were arrested. That's 4300 Northwest 8th Avenue. You cannot go back there. Do you understand?
No.
I'm sorry?
That's not what she's saying. She's saying the address.
The people that was there renting is homeless to them. It's not the shelter at 10:30 was doing that at 10:30.
That's not what she's saying.
For the time being, sir, I understand, but for the time being, you're not gonna be allowed to go back there. Do you understand? All right. So for now, my order controls, you can't go back if you are released. Otherwise, you'll go back before a judge in a few days, okay? Thank you very much. Wilcox, Lamont Wilcox.
Good morning, you speak English?
Yeah.
All right, good morning, sir. Do you speak English?
Yes, ma'am.
All right. Do we have any argument as to probable cause defense?
None of this.
State, you heard us to bond?
Yes, Your Honor, so you would be asking for an elevated bond because he has a long list of prior convictions.
Defense, to be heard us to bond?
Yes, Judge, I believe standing bond is homeless, will not be able to afford an elevated bond. I do understand, the state's position, however, he is, so he would not be able to afford an elevated bond. And charge of nature, we don't believe that him essentially being held no longer be able to.
I'm sorry, ma'am, you're breaking up again. I'm having a lot of trouble hearing
I'm
you.
so sorry, Judge. So,
Okay.
we would be, asking for standard bond. I understand the state position, he is unhoused at this time, so we believe an elevated bond would be equivalent to holding him no bond. So we'd be asking for standard bond at this time.
All right, standard bond is fine here. It's gonna be $500. I'm finding probable cause, sir. You have a $500 bond. Thank you. Ladara Johnson. Ladara.
One moment. They're going to bring it.
Problem.
Judge, can we pass? I don't think he's here and they're looking, so we can pass briefly.
We'll pass, no problem. Next case is Reginald Weaver. Reginald.
Weaver.
Reginald Weaver.
He's not here as well. Can we pass Mr. Weaver?
We'll pass.
Thank you. I think the next one to be on is Cardenas, Edgar Cardenas.
I'm sorry?
The next one who would be on is Edgar Cardenas. The other two people before him.
You're saying those were bond outs, the other two?
Yes, Judge. Last name.
Alright, so Bethel is a bond out.
Both of them are Bethel. They both bonded out.
Got it. Thank you. Edgar Cardenas. Sir, do you speak English?
Yeah, yes, Your Honor.
Defense any arguments to probable cause?
I'm sorry.
I'm asking your lawyer if there's any argument as to probable cause. Let her do her job, okay?
So, Judge, not at this time.
All right. State your interest. Bond,
Nothing from the state, Your Honor.
defense,
Judge, we'd be asking for him to be released on his own recognizance. I don't see that he has any priors. His permanent address is in Miami. So we'd be asking for him to be released on his own recognizance at this time.
state,
No objection.
no objection, will be ROR. Sir, make sure you return to court when you get your notice, do you understand?
She said you're gonna send notice in the mail to make sure you go to court. So you can ignore her. Okay. Good night.
There's a Peter Suarez who's seeking to be let in. Does anybody know who that is? Mr. Suarez, what case are you here on?
Yes, Your Honor. How are you doing? My name is Peter Suarez. I'm with the Health Law Offices of Anthony Vitale. We were called by the family members for an inmate by the name of Alfredo Roberto Fernandez. Case number is felony 25026722.
All right, it's on my felony calendar, the clerks are telling me. All right, we'll let you know when we get to that felony calendar, so tell me the case name one more time.
Hold on, Your Honor. Case number is 2526722. And you want his prisoner number or just his name?
Just his name.
Alfredo Roberto Fernandez.
All right, bring you in when we have that case, okay?
Okay, about how long you think it'll be, Your Honor? By any
I don't
chance?
know, it looks like he has a traffic case and a felony case, so he's gonna be called twice, so just be patient, we'll get to it soon, okay?
No problem, Your Honor. Thank you.
Thank you. Ronald McNeil?
Judge, he's present. Can you speak English?
No more.
Yes, speak English, Judge.
All right, do you have any arguments to probable cause?
Not at this.
Defense, state you wish to be heard as to bond.
Yes, Your Honor, he would be asking for an elevated bond due to the substantial history of prior conviction.
Defense?
Judge, due to the nature of the charge, and the fact that Mr. is wouldn't be able to afford an elevated bond, let the standard bond, we'd be kindly asking for a dollar bond.
You're asking for an ROR?
Well, yeah,
No, okay.
so we'd be asking for a dollar bond.
All right, respectfully, based on the priors, I'm not gonna do that, I'll just standard bond at 150. I'm also gonna issue a stay away order, Mr. McNeil, the place where you were arrested, 1664 Alton Road. You are not allowed to go back to that place, do you understand?
I'm not. I'm
I'm sorry, I can't hear you, do you understand my instructions not to go back there?
Yes, ma'am. I'm not going to go right. Do practice time.
All right.
Mm.
All right, sir, you're not free to. Nicholas Delgado. Your all set, sir. Correction's gonna take you back. Nicholas Delgado. Did I see that last one? Okay. Did you look at this one? McNeil? Is there up? Fine.
Hello?
Oh, here. Is this something you can resolve? Ma'am, do you want to talk to Mr. McNeil about the possibility of resolving this case today?
Is there an option to say?
We can do adjudication credit time, sir.
Okay. He's gonna accept that.
I'm sorry, you said he will not accept them?
He will accept that.
All right, Mr. McNeil,
Yes, ma'am.
I need you to listen carefully because I'm going to give you some instructions, okay?
Yes, ma'am.
Right now, sir, you've been arrested for trespass to an unoccupied structure or conveyance. You've been asked if you want to take a plea deal on that. Do you want to do that?
Yeah.
Yes? Do you understand that you have the right to fight this case? You have a public defender who's been appointed who can ask questions and challenge the witnesses and cross-examine people to fight this case.
Yes, ma'am.
You understand that if you take this plea, you are giving up the right to challenge that case.
Yes, ma'am.
You're giving up the right to have an appeal, to have anybody talk to you about this case or investigate it and to go to trial. Do you understand?
Yes, ma'am.
You understand that there can be consequences to taking a plea, to having an adjudication of guilt on your record?
Yes, ma'am.
And you understand that this can affect your immigration status if you're not a United States citizen. You could be deported for taking this plea. Do you understand? Knowing all of those things, and have you had the opportunity to speak to the attorney?
Yes, ma'am.
And do you understand all the consequences of this plea?
Ma'am.
And do you still wish to accept the offer that the state has made of adjudication and credit for time served and have this conviction on your record?
Yes, ma'am.
Do you have any questions for me about the nature of this plea or questions for your attorney before we go forward?
Yes, ma'am.
All right. I'm going to find probable cause for trespass to an unoccupied structure, and I'm going to accept your plea of guilty. I'm going to sentence you to credit for time served.
Do you need straps on your throat? Yeah, one in the one.
I do have to impose court costs, sir.
Better before, right?
I'm with
how we're gonna put that plan.
who's on mute?
Yes. On.
What plan? The what?
You're gonna get 5
Open the
minutes.
door. I'll figure it out now.
Thank you. So, Judge, do we have to consider waiving court consequences on this?
All right, I'll do that. I'll waive the court costs.
Thank you.
All right, I'll waive all costs and fees and send you to adjudication and credit for time served. Do you have any questions, sir?
Yes, ma'am. Very.
Have a good day. Good luck. Thanks.
Thank you. I appreciate it. All right, Mr. Delgado, Nicholas Delgado. And on a seat.
One moment.
No problem.
He's coming. She's walking a little slow.
No, thank you.
Judge, he's present.
All right, good morning, sir. Do you speak English?
Yes, sure.
Yes?
Into the-
Do you speak English, sir?
What? She said, I say English.
Would you prefer to have the assistance of the Spanish interpreter? Mr. Interpreter, please, do you prefer to have your assistance?
Of course. Señor Delgado, necesita usted los servicios y un intérprete en español.
He says he understands English better, so we can proceed in English, Judge.
Okay, proceed in English. Defense, do you have any arguments as to probable cause?
Not at this time.
State, do you wish to refer as to bond?
Yes, Your Honor, in the last 4 months, the defendant has had 3 convictions and 1 withhold. 2 of them being for the same charge, so we would ask for an elevated bond of 500.
Defense?
Judge, so we will be asking for a standard bond. In this case, he is homeless. Nature of his convictions, I believe, are petty theft disorderlies, all misdemeanor, Judge. We believe that the nature of this charge doesn't require an elevated bond. We will be merely asking for standard bond.
All right. Based on the history and the nature of this offense, I'm gonna issue a bond of $500 stay away order. Sir, I'm gonna give you a bond of $500, and if you are released, you need to stay away from 6700 Collins Avenue. That's the place where you're arrested. Do you understand? I need you to acknowledge, do you understand? You cannot go back to that place where you were arrested. Do you understand? All right.
Judge, it's 500 on which case?
I only have 1 count.
Yes,
E 25-27439. This is an M2 petty theft.
Thank you, Judge.
Okay. Jose Acosta.
Hey, good morning. You,
What do you want me to do?
here. Judge, Mr.
All right, Mr. Acosta, do you speak English?
Yes,
Would you prefer the interpreter?
I can understand what you're saying. So, no, let's go to see. I think I can do it.
Okay, if you want the interpreter, just let us know. He's right there on standby. Defense, do you have argument as to probable cause?
I any probable cause for this at this time.
State, do you prefer us to bond?
Standard bond is fine with the state.
Defense?
So Judge, we would be asked for a reduced bond on count one, standard bond in count 2 and 3. Based off of the form, I believe that we should go into retrieve items from his house. We don't need that. We believe respond for the as after warning appropriate.
I'm sorry, I can't understand you. I had it until then I left.
Sorry. So we would be asking for a reduced bond on count 1 and standard bonds on counts 2 and 3. So 150 on each count, totaling in 450.
What's the basis for the argument for reduced bond?
The basis for the argument for reduced bond is based off what I'm looking at. It looks like he was just retrieving some items from his home. So even though he was evicted, it looks like he was just retrieving items from his home. It doesn't seem like his conduct was malicious in nature, so we just be asking for reduced bond on the first count and then standard on the second and third.
I'm gonna issue bond of $300 on count 1 on the traffic tickets. I'm gonna issue a bond of $150 on the DWLS. That's the citation ending in BLE. And I'm gonna issue $300 on the second citation ending in BME. I'm also gonna order, sir, that you stay away from 11225 Northwest Flagler Lane. Do you understand my instructions?
Yes, sir.
Don't go back to that place.
And just confirm,
Your Honor,
Yes, ma'am.
in reference to Mr. Acosta, he's on felony probation, F-22-2364.
Okay, I needed to know that. State? F-22-2364.
The state doesn't have an open felony.
All right.
Wait, well, we have, for probation, is that what you're asking? Because they do have the F-22-2364, is that what you
Yeah,
stated?
it does look like he was sentenced to 7 years probation. Is there gonna be a felony hold on that?
There should be, if we would ask for one, Your Honor, yes. Apologies, it wasn't showing as an open case.
All right. Madam Clerk, what do I have to do to have him held on that?
Just stated.
All right. There is gonna be a felony hold, sir. You're on probation, and this would be a violation of your probation. From the nature of those charges, I do need there to be a felony hold. So you'll go back and see a judge, okay?
Judge, in light of the felony hold, we'd be asking for a dollar bond on each count because he's not going to be reduced to the felony hold.
No, ma'am. New charges.
I'm sorry, Your Honor. Repeat the bond, please.
On count 1, it's gonna be $300. On citation ending in BLE, it's $150, and on the citation ending in BME, it'll be $300. All right. Felix Ocana Concepcion. Case number I have 25-27443. Are you Mr. Ocana Concepcion? Are you Mr. No?
No, Judge.
No problem.
One moment.
No problem.
Your Honor, he held on the AC no bond, F 25 2450.
Say the case number one more time.
F 25 2450.
2450, and that's on Mr. Okada Concepcion,
Yes, Your Honor.
and it was no bond.
Yes, Your Honor.
All right. You should we address this one? I mean, he's got citations, he's got a new charge. Okay, I wrote that. So. All right, we move on. Sergio Valiente Riveron.
Your Honor, these are added charges.
I'm sorry?
These are added charges.
All right, you're Mr. Riveron?
So I think we just addressing Mr. O'Connor Concepcion. This is him.
Okay.
All right.
My understanding is there's a felony hold, you're being held no bond on F 252450. So you're gonna be on that front of that judge, okay?
What is it?
Yes, he also has a misdemeanor case that needs to be addressed, Your Honor.
That is the misdemeanor.
No. This is, all right. Any argument as to the probable cause in the misdemeanor?
Not at this.
All right, I'll find probable causes to the misdemeanor state to be heard respond.
Yes, Your Honor, the defendant does have prior convictions and has the felony hold, Your Honor, so we'll defer to Your Honor, we can do standard.
Defense,
Judge, we be asking for dollar bond because he's not getting out because he's being moved on his felony.
$500 bond.
Okay.
The other.
The case of this correction for me to do Russell. All right, Duvon Russell.
Your Honor, Mr. Russell refused court.
We'll reset. This is how many times has this been reset? Or what do you mean?
Your Honor, this is the third refusal.
Defense, do you want to waive his presence?
Not at this time, Judge.
All right, it'll be reset. All right, that takes us to Sergio Rivera.
Is the reset for Mr. Russell for tomorrow, 12/14?
He can't waive his presence, then yes, he gets reset each day of those days.
Okay.
All right, you're Mr. Rivera?
What? Said you.
Oh, can you finish? He requires assistance of the interpreter.
All right. Sir, you're Mr. Valiente Rivera?
¿Es usted Valiente, apellido Valiente?
Sí.
All right.
Yes.
Defense, do you have any argument as to probable cause?
Judge, I don't have any form on this case, so not.
Your Honor, these are added charges.
Su señoría le acaba de preguntar al abogado de oficio que se encuentra a su izquierda si ella tiene argumento alguno en contra del motivo fundado de su acusación. Ella indicó que no, y los carceleros acaban de informar que esto es una acusación que se le está añadiendo.
All right. The arrest affidavit reflects that the officer observed the defendant on a scooter, the Florida license plate, failing to stop at a stop sign, and a check of records license revealed that his license was suspended on 9/20/24 and notice was sent. I'm going to find probable cause based on the allegations of the affidavit.
Your Honor,
Yes, ma'am.
on yesterday, Judge Box sentenced him to 5 years of probation. When he was getting ready to be released, this bench warrant popped up.
Okay.
Que le está indicando que usted está sentenciado a 5 años de libertad condicional y anteriormente su señoría dice que la gente lo detuvo a usted porque usted estaba manejando un scooter con placa y que cuando él lo detuvo porque usted no se paró en una señal de pare, se enteró que usted tenía la licencia suspendida desde el día 24 de septiembre. Your Honor, was it September 24th or September of 2024?
September 2020.
Pero ese tiempo no pagué ya. No pagué ese
No, listen to your lawyer.
I've paid for it already. I paid for it.
All right. Corrections, are you saying you don't need a bond on the misdemeanor case, you just need it on the bench warrant?
y no asistí a la corte porque
Your
I
Honor,
didn't go to court because
No. Okay.
Your Honor, for Mr. Valiant Riveron, on yesterday, he was getting ready to be released, and this bench warrant popped up. I don't know what they have for the misdemeanor.
que está indicando que esto fue una orden de arresto que usted tenía, que
Madam
cuando lo iban a soltar ayer.
Madam Public Defender, the issue is the clerk is advising that it looks like your client was in custody at the time the bench warrant was issued. So the failure to appear,
Wasn't willful. Judge would be asking him to be released.
here's the thing. Right now, it sounds like your client offered a plea that would resolve his underlying case. Corrections, are you saying that the judge no longer took the plea? Or was that sentence issued to 5 years probation?
Your Honor, on his felony, F-25 6418 Bravo, he was sentenced to 5 years probation on yesterday. When
Okay,
he was getting ready to be released, this bench warrant popped up.
got it. All right. I'm gonna,
Los carceleros están indicando que con el delito mayor que usted tenía de este año, enumerado 64-1-8, letra B, donde usted es el coacusado, usted le impusieron 5 años de libertad condicional, pero cuando lo iban a soltar, se dieron cuenta que usted tenía una orden de arresto.
sir, I'm gonna release you on your own recognizance as to the bench warrant.
Señor, su señoría, le va a dejar usted salir bajo su propia responsabilidad o palabra bajo esta orden de arresto.
But understand you're in a precarious position and it's important that you appear for your next court date.
Pero entienda usted que usted está en una posición ahora muy precaria. Este caso
This-
no se ha cerrado, usted tiene que volver para resolver este caso.
This case is not closed, and if you don't come in, you will be arrested again.
Este caso no está cerrado, no está desestimado, no está anulado. Si usted no va a resolver el caso, va a caer preso de nuevo.
okay.
From the
Ok,
record,
ok.
it also appears that your driver's license is not valid at this time.
Inclusive, su licencia de conducir no es válida por ahora.
So I am going to order that you not drive a vehicle, including a scooter, no driving, until you have a valid driver's license.
Your Honor, previously to that, he said it's not, indicating that it was.
Thank you.
Su señoría quiere decirle a usted que ella no quiere que usted vuelva a manejar ni siquiera un scooter, cualquier vehículo que necesite placa. ¿Usted entendió?
If you drive
Ok,
again,
ok.
if you drive again, not only could you face criminal penalties, you could also be held in contempt of this court.
Y es más, si usted vuelve a manejar, no solamente va a tener un delito nuevo, puede hallarse usted en desacato al tribunal.
No.
He said,
All
no,
right.
but I couldn't understand the rest.
Thank you, sir. Have a good morning.
Gracias, señor. Pase usted buen día.
Come on, Delgado. I'm sorry?
No, that was correction calling in.
Okay. Gabriel Delgado? Are you Mr. Delgado? Do you speak English?
Ma'am.
I'm sorry?
Yes, ma'am.
All right. Defense, any argument as to probable cause?
One from the judge.
Your Honor, it was to Ms. Delgado.
Mr.
Yes.
Benjamin?
Yes, he went to court on yesterday on his 2 felony cases, F-23-8292, F-23-8349. He was reinstated to probation per Judge Hirsch. When he was getting ready to be released, this bench warrant popped up.
Correct. So he was in custody at the time he received this bench warrant, so it'd be asking the ROR.
Well, he was in custody at the time of this bench warrant corrections.
He,
The warrant was issued December 4th.
Yeah.
he's been in custody since December 3rd.
All right. State, I'm gonna ROR and then show an objection. All right.
Being as he was in custody, the state wouldn't. have that.
Sir, I'm gonna release you on your own cognizance, which means I'm gonna let you out without bond.
Okay.
But it means that you need to appear in court for the next hearing. Do you understand?
Yes, ma'am.
If you don't appear, you can be arrested.
Yes, ma'am.
All right. I'm also gonna order that it appears from the base of the record that you do not have a valid driver's license at this time. So I'm gonna order that you not drive any type of vehicle in Florida. Do you understand?
Yes, ma'am.
If you do drive a vehicle, not only can you be arrested again, you can also be held in contempt of court.
Yes, ma'am.
All right.
Your Honor, this is Joanne Hennessy for the City of Miami Beach. I just want to confirm the remainder of the calendar is traffic only.
Yes, ma'am.
Thank
No.
you. If I could be excused, I'll be back tomorrow.
I'm sorry?
We still have 2 misdemeanors.
They're
Oh,
right. That's 2 misdemeanors. But I don't think
Okay.
either of those were you announced, Reginald Weaver or LaDarren Johnson.
Yeah, I believe those are state cases, Your Honor.
Correct.
I believe,
All
If
right.
I could be excused
You
then?
can be excused. Have a good morning.
I'm so
Thank
sorry.
you. Good day.
All right. On Resevend Walney. All right. This also appears to be a bench warrant.
I'm sorry, Your Honor. We're addressing,
Resmond Walney. Is that you?
Yes.
And do you speak English?
Yeah.
All right. Defense, have you reviewed for probable cause?
Yes, but we don't have any arguments at this time. Sorry, I have no arguments at this time.
So there's a new count of no driver's license, or is that the old case? That's the bench warrant. Somebody help me out? Huh? So there's no count? Right, state, do you wish to be heard?
Nothing from the state, Your Honor. We would just ask for standard.
Defense?
Just a main valid learner's permit, it just they have that as well.
Unfortunately, we don't have the TPO because the citation is still too new.
Okay, well, wait. That judge asked if he can release some cognizance.
The failure to appear. I'm gonna reduce the bond. I'm gonna make it 1,000. Bond of 1,000. Then I have Morales Yasser or Yasser Morales. I believe it.
Your Honor, Mr. Morales also has a hold for the Department of Corrections. His release date is 12/14/25.
All right. You need an interpreter, sir?
Yes, sir.
All right, with the assistance of the Spanish interpreter, Spanish, correct?
Yes, ma'am.
All right. Defense, I don't see a new state you wish to be heard as to bond.
Yes, Your Honor, we have notes that there is a immigration hold on this. It says do not release, no bond, do not release. So the state's position is for Your Honor to honor the hold.
Señor, los carceleros acaban de informar que usted tiene orden de retención de parte del Departamento de los Carceleros. Usted tiene una sentencia que caduca el día 14 de diciembre. Además, la Fiscalía tiene ciertos apuntes sobre su fianza, donde indica que usted tiene orden de retención del Departamento de Inmigración y que no se le conceda fianza.
No, sir, you have a lawyer who's gonna talk for you?
Señor caballero, usted tiene la doctora que está a su izquierda, es su abogado, y ella hablará por usted.
And ma'am, I was incorrect. There is a new charge of driving with a license suspended on one of the A forms. So do you wish to address probable cause on that? And then after that, you can address bond.
Judge, if
Usted
I,
se le acusa en esto es de manejar con licencia suspendida. Le están preguntando a su abogada si ella quiere o tiene algún argumento en contra de motivo fundado.
Judge, if I knew, I missed what Miss King was saying earlier. Was he in custody? Was he in jail?
No, en prisión.
Am I wrong?
So, Judge,
Sí.
what dates did he receive the bench warrants? Because I believe he was serving a prison sentence.
Su abogado está indicando que ella entiende que usted estaba en prisión.
It looks like there's a bench warrant for failure to appear for trial. On
Hay
a
una
citation.
orden de arresto porque usted no se presentó a un juicio.
Then there's also when they picked him up on the bench warrant, he was driving, so he was charged with driving with a suspended license.
Y cuando lo recogen por tener la orden de arresto, también estaba manejando, así que también lo arrestan de nuevo por manejar con una licencia suspendida.
So, Judge,
Hang on, the clerks are saying there may also be a felony charge.
E inclusive creen que tiene un delito mayor también.
Okay. Corrections, do you know if there's a felony attached to that new case?
Y los carceleros saben si también tiene el delito mayor.
Your Honor, in reference to Mr. Morales, he was in state prison.
Él estuvo en prisión estatal.
Let's handle one thing at a time, because I think we've all got a lot of questions here. So let's start with, on the new case. You know what? Oh, it's a new case for her.
Which
I'm looking at it, the arrest date is 4/20/24. Did this not even be here?
I'm sorry, what question are you asking, Your Honor?
Right now I'm talking to the clerks, because I've got so on this case, what do you want me to address?
1 second. No, you're addressing the bench warrant for the WLS knowingly 60E, this one only. That's the only one they put on count. But the other, the other case is AJP JNX.
I just don't understand why there's two separate arrest affidavits. Right. But it's the same citation as this one. Right? I just don't know why we have both here.
Calculations. This was the arrest that.
And then he gets picked up on the bench warrant plus another bench warrant. So he has two separate bench warrants and two separate cases. Okay. All right. Do you know the bench warrant for that one? Yes, because and what was the amount of the bench warrant on that one? Okay.
That's correction. Corrections was he in custody on 7/5/2024?
He was, I said he was in state prison. I don't know
Hmm.
the date that he went to state prison.
So I don't believe we would be able to tell.
He says defendant serving a 10-month sentence with DOC. Release date is 12/14/25.
If I what it looks like to me is that he was serving almost an 11-year prison sentence. And whenever the inmates are going to be released from, I think, Everglades, they would bring them here for release. So that's why he was gone. So it's my understanding that he received bench warrants while he was serving a prison.
But then he was picked up also in that meantime, right? So he was out at some point within the last years because he was picked up on that warrant and given a new.
Well, he was picked up on 12/11/25.
Yeah, so he's out at some point.
Can you ask your client
Your Honor,
without telling me, has he been released or was he transported here from?
Your Honor, he was
Señor, ¿usted lo transfirieron de la prisión para acá o usted ya estuvo fuera?
Yo estaba de para acá.
Disculpe, dígame.
Okay, corrections is answering you. Corrections is saying he's never been released.
Yes, he was transferred from prison to
Okay.
here.
Los carceleros están indicando que usted lo transfirieron de la prisión para acá, que usted nunca salió.
No.
Is that there should be a hold for immigration. The state at this moment in time would object to ROR, any type of standard bond. We've been advised it's a hold for immigration, that he poses a risk to national security, and that's it.
Corrections, if there's a hold for immigration and I set a bond, he still can't bond out until the immigration hold is resolved, correct?
he could bond out, but he has the whole immigration.
So he'll still be held.
To pick him up.
He can bond out, right? But they're gonna come get him. But I guess it's our position that and if the interpreter can interpret it just so we're on the same page, I did let him know if he was released, then he would possibly be going into immigration custody. So if they can interpret that just so he understands what we're kind of talking.
Que si usted, cuando salga, lo más probable es que usted entre a custodia ahora del Departamento de Inmigración, señor.
Sí, correcto.
Okay.
Yes, correct.
In light of which, because he received these bench warrants while he was in the custody of the state of Florida, we would be asking for him to be ROR.
Okay.
Lo que su abogado está pidiendo es que lo dejen salir bajo su propia responsabilidad y o palabra.
Okay.
Okay.
I am going to issue a $1 bond on each of those.
Okay.
That way,
Understood.
Usted le va a imponer $1 de fianza en cada una de las acusaciones que le quedan pendientes.
all right. $1 bond on each of the 2 bench warrants. Is that all you need? Correction?
$1 de fianza en cada una de las órdenes de arresto. Eso es todo.
I'm sorry, what are you asking, Your Honor?
You only need a bond on those 2 bench warrants, correct?
Correct, yeah.
All right, $1 bond and the felony, the immigration hold remains in effect. All right, we're gonna move on to Jackson Rashad Jackson.
Does he's present? Jackson's present in English.
I'm sorry, we can't hear you.
Mr. Jackson is present in English.
All right, do you have any arguments to probable cause? This is a bench warrant. State, do you wish to introduce a bond?
Nothing from the state, Your Honor.
Defense?
Judge would be asking what's in their bond.
The bench warrant on this is $1,000. You want to tell me why you didn't appear?
Judge, he's letting me know that he lost notice, but we did not hear.
All right, use the bond of $500 on that bench warrant. So it'll be a bond of $500. It's important that you show up for court, sir. All right, thank you. Patrick Watson.
Your Honor, he has a related felony. He'll also be back on your bond hearing calendar.
We'll address the felony later. Any argument as to probable cause of the NDL?
Not at this.
State, do you wish to be heard as to bond?
Your Honor, we would just be asking for an elevated felony as a felony fleeing and eluding for 2023. His license is currently revoked. He has a DUI conviction from 2023 as well, and a DWLS knowingly guilty conviction from 2024.
Defense?
Judge, would you ask for standard bond, please? Would you ask for bond addition? Does have another felony where a bond will be issued on that count as well. We ask for standard driving.
It's gonna be a $500 bond. Okay, based on the nature of the charges and the prior driving issues. Sir, I'm also going to issue a no drive order. From the face of the record, it appears that you do not have a valid driver's license. I'm going to order you not drive a vehicle until you have a valid driver's license. If you do, violating not only the law, but also this court's order. Do you understand the instructions?
Ma'am, this
All right.
one handful.
We'll see you back this afternoon.
Hi, good morning. Good morning. English or Spanish? Excuse me. Do you speak English or Spanish?
Your Honor, he has a hold for immigration.
There's an interpreter. Would that be?
With the Spanish interpreter, Franco YK.
Yes, that's me.
Ahí, usted tiene una orden de retención por parte de inmigración.
It looks like there's a bench warrant and a new charge. Defense, do you have an argument as to probable cause on the new charge?
Señor, usted tiene una orden de arresto y una acusación nueva. Le están preguntando a su abogada si ella tiene argumento en contra de motivo fundado en la acusación nueva.
Nada de eso.
Ella está indicando que no por ahora.
Am I reading this correctly that the bench warrant is from 1998?
Esto es correcto, la orden de arresto es de 1998.
No.
No.
Be heard as to thought.
Yes, Your Honor, we would ask that the bench warrant amount be implemented. Case, he's been able to evade any type of proceedings for the last 20.
Su abogado de oficio está pidiendo que no lo retengan por esa orden de arresto.
Your Honor, we would also ask for GPS monitoring if he is going to post the bond, just because it is clear that he has been able to evade the law for more than 25 years and might be able to.
Also hasn't been arrested.
Están pidiendo de que si acaso le conceden la orden, le conceden dejarlo salir, que tenga tobillera tipo GPS, ya que usted evadió la ley por más de 25 años.
State, do you want to say anything about the failure to appear or make an argument as to bond?
Le están preguntando a los abogados de oficio con respecto de por qué usted no se presentó y tal vez qué va a suceder con la fianza.
Yes, but I say state, sorry, defense, do you have an argument as to the bond or what the reasons for the failure?
One moment.
Thank you.
So, Judge, first, he's letting me know that the date that the bench warrant was issued is incorrect. It should have been 1996, and he was in custody. But our position is the same as the court. He has not gotten in check for 27 years. We don't think a $5,000 bench warrant on a 1998 case, possibly 1996, would be appropriate at this time. He has not picked up any charges in that time, so we'd be asking for. We would be.
Okay. You're asking for
standard bond on the valid driver's license, and a dollar bond on the case that you received the bench warrant in possibly 1998, possibly 1996.
Ok, su abogado de oficio está indicando que usted le dice que no fue una orden de arresto del 98, sino del 96. Y ella está explicando que por eso no le deberían imponer fianza de $5,000 porque no sería adecuado. Además de que ella está diciendo que durante todo ese tiempo usted no tuvo más contacto con las autoridades y que si acaso hay que imponerle fianza, sea fianza de rigor e imponerle una fianza de $1 por estar manejando sin licencia válida.
Does your client have an address at which he can receive mail right now?
Your Honor, I apologize, I couldn't hear you.
I asked if he has an address that he can receive mail.
Yes, he does. Now, it's changed. It's different from what's in the restaurant, but I can probably change the address.
All right. State, you want to?
Yes, Your Honor. At the very least, if Your Honor has found that him not receiving any charges in the last 6 years is enough reason to not implement the current warrant. The state understands, however, at the very least, we ask for standard for the DUI. I don't think that there's been any reason posed as to why it should be reduced to $1 for the DUI. Furthermore, it appears that he was aware of the time that a bench warrant was implemented because he even says that, oh, that's a mistake. That's not the same time it was. So at the very least, it is 1,000 in the DUI.
All right. Court's
Su abogado de oficio pidió que le reducen la fianza y que lo dejase salir. Sin embargo, la fiscalía está indicando que por esa acusación de manejar embriagado, que usted inclusive tanto sabía que existía que hasta mencionó, eso no fue del 98, fue del 96, y están pidiendo que le retengan aún así confianza. I can't hear you at all, Your Honor.
I'm sorry, that was off the record. I'm gonna set bond at $150 on the citation ending in E9P, and I'm gonna reduce the bench warrant bond to $1,000 as a bond. Sir, if you bond out, I'm gonna order that you not drive unless you have a valid driver's license. Do you understand?
Señor, le van a reducir la fianza le van a imponer fianza por no tener licencia válida, solo $150. La orden de arresto será solo de $1,000, pero su señoría le va a indicar a usted que ella le está ordenando a usted no volver a manejar hasta que tenga licencia válida. ¿Usted entendió eso?
Yes.
Yes. Okay, he
All
said.
right. Thank you, sir.
Gracias, señor.
Next case I have,
I'm sorry, Your Honor, what was the bonds for Mr. Waki?
150 on the new case and 1,000 on the bench warrant.
Thank you.
Rolando Martinez Reyes. Bond out.
Bond out.
Where do I look? You need to run the rest affidavit too?
No.
Mr. Martinez raised the bond out, Judge.
Michael Valoria. Good morning, sir. Speak English?
Yes, I do.
It looks like it's bench warrant for failure here at arraignment on October 1st.
Yeah.
State needs to be heard.
Your Honor, Mr. Valoria is a VFox.
Right?
Yes, Your Honor, as he's a VFOS, the states could not agree to releasing the defendant. Just one moment. You don't. Just one moment to confirm, Your Honor.
All right.
But that is on the felony probation. The rest of it.
Do you all want this one?
If you could.
Is that okay? All right. Corrections, we're gonna pass this one for a few minutes. We'll come back to it. Let's go on to Hector Sanchez. Then Charles Rion.
Sanchez is a
Brogdon, I'm sorry, Charles Brogdon.
Brogdon is, oh, okay.
You're Mr. Brogdon?
Yes, ma'am.
Do you speak English?
Yes, I do.
All right. Any argument as to probable cause?
Your Honor, Mr. Brogdon
Has a felony?
felony. He'll be back on your bond hearing calendar.
All right. Any argument as to the probable cause on the DWLS?
Not at this.
State as to bond?
Your Honor, state stand with, fine with standard in this case, and we could address the felony as it appears.
Defense,
Judge, would be asking for dollar bond traffic, while the A form writes that his driver's license was suspended, there's nothing, that I think would acknowledge to driving his suspended license, so we ask for dollar bond. And even though on the arrest form it says that defendant was provided notice of the suspension, we don't believe, he says that he was not provided notice, so he did not know that his license was suspended.
all right. I'm gonna set bond at $150. And we'll see you for the felony case in a little bit, sir.
That was 150, correct?
Yes.
150.
Thank you.
Then I have Eliezer Arauz Torres. Are you Mr. Torres?
I don't think she said, are you?
Yeah.
Sure.
Do you speak English?
Ma'am.
All right. It looks like this is a bench warrant for failure to appear at arraignment on December 8th. State, do you wish to be heard?
Nothing from the state.
Defense?
Judge, we would be released on his own recognizance. I don't see any priors from Mr. Torres. Additionally, he did let me know that he is represented by counsel on the traffic, so the counsel will file a notice here on his behalf, so he asked to be released on his own recognizance.
Can you give me information about how long he's lived here or why he failed to appear on that date?
So failed to, he said he didn't receive notice.
But he had counsel?
He obtained counsel after. That's what for this.
Between December 8th and today.
Right. And he got more on.
All right. Does your client live here?
Yeah.
Valid address? How long has he lived here?
Yes, Judge. His whole life.
All right. I'm gonna reduce the bond to $200.
Okay.
Sir, from the face of the record. Oh, no, I think I don't see anything suspending his license. All right. So, yeah, so then. Defense, would you rather pretrial services or the $200 bond? They did.
Pre-child, please.
I don't see Gerald Bland in the waiting room, so I can't have him appear on this. All right. Pretrial services for the $200 bond.
Okay.
I'm sorry, ma'am, I didn't get an answer.
Oh.
Yes.
Yes to which? $200 bond or the pretrial services?
Oh, to the pre-child services.
All right. I'll order pretrial services.
Thank you, Judge.
I'll meet with their representative.
Thank you.
Your Honor, do you want to address the case we have?
Not yet. Alternate bond of $200. You'll fill out the rest?
And
Change. Mario Torres Rojas.
Judge requires assistance of the interpreter, please.
All right, with the assistance of the interpreter. I need my interpreter back. What was it?
Flores.
This is Mario Antonio Flores Rojas. In the meantime, corrections, it looks like we're going to be ready to address Nathaniel or Michael Gloria next. But I do need the interpreter for this one.
Some breaking news.
There. All right. Morning, sir. We have the interpreter for you. Defense, do you have any objections or arguments to probable cause?
Buenos días, señor. Le están preguntando a su abogado de oficio si acaso tiene argumentos en contra del motivo fundado en su acusación.
So, Judge, we would be arguing that there is no probable cause for driving with a suspended license knowingly. At best, he could be charged with a citation of driving with a suspended license knowingly, but I don't see any evidence of knowledge in this arrest form, so we'd be arguing no probable cause for this.
Ella está argumentando que a usted solo se le podría haber acusado por una infracción que es manejando con una licencia suspendida, pero no a sabiendas. Ella no ve ningún tipo de evidencias que demuestren que usted tenía conocimiento.
Apparently, your client also has a bench warrant for DWLS.
Has a what, Your Honor?
A bench warrant.
Aparentemente su cliente además tiene una orden de arresto por también estar manejando con licencia suspendida.
Which I believe would be considered evidence towards the knowingness element. Going to find probable cause over your objection.
Esto se consideraría pruebas, así es que están denegando su argumento en contra del motivo fundado.
State, do you wish to be heard as to bond?
Standard is fine, state.
La fiscalía, su señoría le preguntó a la fiscalía respecto de la fianza. La fiscalía está de acuerdo con que la fianza sea fianza de rigor.
Defense, I'm not inclined to issue standard bond despite the state's argument. Do you have any argument?
You said you don't want to give him.
I'm disinclined to do that. He's on.
Ok, la juez no está inclinada en conceder fianza de rigor. Le está preguntando a su abogada que qué argumenta ella.
Judge, may I?
Supposed to appear on a DWLS case, failed to appear, and then alleged to be driving.
Él no se presentó ante una acusación de manejar con licencia suspendida y volvió a estar manejando con la licencia suspendida.
Defense, do you have argument?
I would be asking for standard bond.
Su abogado de oficio está pidiendo que le impongan fianza de rigor.
I'm going to issue a $500 bond on the citation ending in 6K. I'm going to issue a $1,000 bond on the Benford case, which ends in GZE. I'm also going to order, sir, that it appears from the face of the affidavits here that you are not in possession of a valid driver's license. And so I'm going to order that you not drive until you have a valid driver's license. If you drive, not only do you face arrest, you also will be in violation of the school, be held. And do you understand?
Señor, su señoría le va a imponer $500 de fianza en la acusación nueva, $1,000 de fianza por la orden de arresto, pero ella también ha determinado que usted no tiene una licencia válida y le está emitiendo una orden de no manejar. Y es más, si usted vuelve a manejar, no solamente lo pueden arrestar, sino que usted estaría en desacato a las órdenes de este tribunal. ¿Usted entiende que no puede volver a manejar? I couldn't hear him.
He answered yes. All right. The next case is Alfredo Roberto Fernandez. I believe this is the case where we have the private attorney.
I'm sorry, Your Honor, for Mr. Flores, the bench warrant was 1,000 and the new case was 150.
500.
Thank you.
And the no drive order. I do need Mr. Fernandez's attorney.
Hi, Your Honor.
And Judge, this private attorney is going to is going to be his first speaker.
Yes.
Mr. Suarez, are you aware if your client speaks English?
Now been admitted.
Yes, he speaks English.
For the
Okay.
record, the attorney is Peter Suarez. Mr. Suarez, does your client speak English?
Yes.
Yeah.
All right. Your client has a related felony, so we're only going to address the reckless driving this time. Do you have argument as to probable cause?
Okay. Sorry, didn't hear you, Your Honor. What was that?
I said we're only going to address the reckless driving at this stage. I have to address the felony on my next calendar. Do you have any argument as to probable cause on the reckless driving?
Not at this time, Your Honor.
State, to be heard as to bond.
Yes, Your Honor, he has a 2023 DUI, and being as the pattern.
2023 DUI?
Yes, Your Honor, so state we asked for, an elevated bond.
Defense?
Your Honor, I believe that DUI was up in New York, if I'm not mistaken. He is gainfully employed and he does work at Miami-Dade and FIU as a professor.
All right. Post stand. Well, I'm sorry, is the DUI the only prior you have?
Yes, Your Honor.
And he's been sentenced on that?
Yes, Your Honor.
And the term of probation is over?
I will advise us because it's in New York. We just have national priorities indicated.
All right. It'll be $300 bond on this case. We'll address the felony when we come back, okay?
Thank you, Your Honor.
Thank you. We'll have a seat or we'll bring back in.
And Judge, just for the record, PDs are discharged on Mr. Fernandez's case.
Yes. Faison Clinton.
No, man. How are you? Chilling, bro. You?
Are you Mr. Clinton?
Yes, ma'am. Good morning.
Speak English?
Yes, ma'am.
This is a bench warrant on a DWLS. State, do you wish to be heard as to bond?
Nothing, Mr. Your Honor.
Defense?
What over?
What number?
Can tell me.
No, you now gotta wait for the felony. I just did the traffic.
What was
warrant.
the plan?
You may want to be on mute while you're having that conversation.
Shooting police.
Oh, I thought he had a different one that you didn't know about. Like, oh my God.
Yes, but I didn't know.
Yeah, it's to be on mute. I mean, mute. So, may I ask you is of this bench warrant, please?
The value on the warrant right now is $150. It was a failure to appear for arraignment back in 2023.
Yeah.
Okay, so Judge, which my understanding he didn't receive notice. I do believe the notice went to the address that he resides at. He didn't know that he had for it, so we wouldn't have been able to change his address in the system. It said, based off of, hold on. So the address that he lives at, that's listed on the arrest warrant, is his current address. He said he's been living there for 4 years, so that he didn't receive notice at the address. And considering that the bond was complete, $150, we just be asking him to be released and we can change his address.
I'm gonna leave the bond at $150. This is 2 years, so $150 on the bond. Thank you. Then I hand his log as a bond out. Thank you. Then I have Fernandez Vaz. Is that you, sir?
Yes,
Do you speak English?
Mr. Hernandez Vasquez has a whole immigration.
He would have the assistance of the interpreter.
All right, the assistance of the interpreter. I have here that Mr. Voss failed to appear for arraignment in 2023. It's a $1,000 bench warrant.
Señor, usted no se presentó ante la acusación o instrucción formal de acusación el 2023, así es que tenemos fianza de $1,000 o una orden de arresto de $1,000 en su contra.
State, here.
Yes, Your Honor, we would ask for standard in this case, and also the immigration hold to be placed. He does have prior details, slightly more remote, so the state is fine with standard.
Defense?
La fiscalía está pidiendo fianza de rigor, and I apologize, State, you mentioned immigration or no?
Yes, an immigration hold.
Y además también la fiscalía tiene información que usted tiene una orden de retención en contra suya.
Okay, so Judge, I believe he already does have an immigration hold. Considering that he has the immigration hold, and this was going to appear at a arraignment, we got a $1 bond, because it's post-mortem, he can go into the immigration.
Okay.
Su abogado de oficio está pidiendo que ya que usted tiene orden de retención de inmigración, que le impongan o solo $1 de fianza.
This is a failure for over 2 years. I'll reduce it to standard bond 150.
Is it 150, Your Honor?
Yes.
Su señoría dice que usted ni siquiera se presentó a su instrucción formal de acusación, pero se lo va a reducir la fianza a $150.
And the immigration hold will remain in effect.
Y claro, tiene usted una orden de retención por parte de inmigración.
And may, Sir Tucker, can you let me know that once he responds, we'll go into the custody of immigration, please?
Y entiende usted, una vez que usted pague la fianza, usted entrará en custodia del Departamento de Inmigración.
All right, Seth Lintz.
Your Honor, he has a related felony. He'll be back on your bond hearing calendar.
Thank you. All right, you're Mr. Lintz. Do you speak English?
Yeah.
All right, defense. You have going to be heard as to probable cause just on the leaving the scene.
Sorry.
At this time.
All right, state, do you wish to be heard as to bond?
The state is fine with standard bond and we could address that felony as a proposed.
Defense?
May I ask what the felony is?
It looks like it's possession of a controlled substance, 3 separate counts plus a drug paraphernalia possession.
So, Judge, at this time, we asked him for him to be. We would ask him on the $50, Judge. I don't see that he has any priors from the charges that currently being that he was arrested on. At least from my notes, that's what I see. So we'd be asking him to respond to $50. I don't see that he has any.
Yeah. The portal issue for $250. And we'll see you back on the next calendar, sir. Next case is Toledo. I have the bond out. Then I have Jonathan Martinez.
Morning.
Good morning, sir. You speak English?
Yep.
All right. State, defense, do you wish to be heard as to probable cause?
Not at this.
State, do you wish to be heard as to bond?
Yes, Your Honor, state would ask for a standard bond of $1,000.
Defense?
One moment. So, Judge, that this, he had no priors before this arrest. He asked for a refund of $500.
I'm sorry, I couldn't hear that. Say it again.
I'm sorry. Considering that he has no priors, we'd be asking for a $500 bond.
State?
Your Honor, the state would not agree to ask for reduction in bond.
Yeah, they asked for 500. Defense, you haven't given me any basis. Do you have any information about where he lives, what he does he work?
So, Judge, in Miami, he does work currently as a paralegal. He has no priors, so we'd be asking for a $500 bond. He would be able to post that bond and return to court because he is local.
How long has he been in Miami?
His whole life.
Your Honor, I don't believe anything was provided that would or should incline your offer to deviate from standard bond. It is standard for a reason as such. The facts of this DUI shows that the defendant was in a position to cause dangers to other people. He was unresponsive in the driver's seat. He was facing against traffic. He had an open bottle of beer in his vehicle and ultimately refused. So the state would ask for standard in this case.
Based on the gainful employment, the time in the community, the fact that there have never been a prior arrest, I don't think it's appropriate to set a bond of $500. I believe this suspension of is at this stage, right?
For refusal, there should be.
Defense, do you have an objection to a no drive order?
I do, Judge, because there's like he could receive a hardship license. So I would be asking to not enter a no drive order at this time.
My order says that if he can get a hardship license, then he can drive. But until that time, sir, if you do not have a valid driver's license, you will not be able to drive. Once you have a valid driver's license, be it a hardship license or otherwise, then will be able to. But at this time, I'm gonna order that you not drive a vehicle. Do you understand?
Yeah.
Yeah.
You understand?
Do you need an interpreter, sir?
No. You understand, so we're trying to tell me something.
Okay, that satisfy your objection.
Yes, Judge.
All right. So, sir, if you drive, you can not only violate the law, but also my order. Please comply. All right, takes us to Augusto Malave Diaz.
Judge, he's
And then corrections, we have 3 that we passed, which is Michael Valoria, Reginald, and Ladera Johnson. You're Mr. Malave Diaz?
Yes, I have.
Defense, any arguments to probable cause?
sorry. Not at this.
All right. State, do you wish to Curtis to bond?
Nothing from the state, Your Honor.
Defense?
Judge, based off what I see, I don't see that he has any priors, so we'd be asking for a reduced bond of $50 each count.
State?
No objection.
All right, I'll issue bond of $50 on each count, so that's $50 on the citation ending in 8-3E. I'll issue a bond of $50 on the citation ending in 8-2. I'll issue a bond of $50 on the citation ending in 8-4-3. And I'll issue a bond of $50 on the citation ending in 8-1E. It does appear, sir, that your driver's license is suspended. So I'm going to issue, it's either suspended or you don't have a driver's license. I'm going to issue an order that you may not drive a vehicle until you get a valid license. Do you understand?
Sorry.
I didn't hear.
Do you speak English?
I do.
No.
Okay. I've issued a bond of $50 on each of your cases, so that's going to be a total bond of $200.
Okay.
I'm also ordering that at this time, it appears from the face of the record that you do not have a driver's license. So I'm going to order that you not drive a vehicle until you have a valid driver's license.
Okay.
If you drive without a license, not only do you face arrest, you are also violating my order and can be held in contempt of court. You understand?
I understand.
All right.
All right. Thank you.
Have a good day.
Bye. Happy.
All right. Questions, are you ready to recall any of those other 3?
Yes, Judge, can you please recall Ladera?
Which one?
Ladera Johnson, this is one of the ones we passed.
All right. Mr. Johnson,
Yes.
you speak English?
Yes.
All right. Do you have any objection or argument as to probable cause?
I don't have probable cause at this time.
State, do you wish to convert us to bond?
Yes, Your Honor. One moment. Yes, Your Honor. So in Mr. Johnson's case, he does have a few crimes priors, and the state would also like to include that he has 10 additional traffic criminal priors as well. So we'd be asking for an elevated bond.
Defense?
Judge, we believe that state of bond is appropriate. Mr. Johnson is unhoused at this time, so $500 each count would be a lot, but along with the bond, that would be equivalent to holding no bond, which we don't think is appropriate for the nature of the charges, so we'd be asking for a bond.
Looking at the history here, I'm going to issue a bond of $500 on count 1, $1,000 on count 2. I'm also going to issue a stay away order, sir. Should you be able to bond out of custody, I'm going to order that you stay away from the Chevron on Northwest 54th Street. Do you understand?
Yes.
All right. If you don't bond out, you go before a judge in a few days, okay?
I'm sorry, when you said that, the door was open. Would you
I
mind?
said I found probable cause. I issued 500 on count 1, 1,000 on count 2. That's a stay away order. Your client acknowledged that he would stay away and understood my instructions to stay away from the Chevron on 54th Street. I said if he doesn't bond out, he'll go for a judge.
Thank you, Judge. Okay.
All right, who we have? We had 2 more recalls, correct?
Weaver, Judge.
All right, Reginald Weaver. All right, you're Mr. Weaver. Do you speak English? Do you speak English?
You speak English. Do you speak English?
Yes. All right. This woman next to you is going to represent you. I'm going to ask them, do you have any objections to probable cause?
I don't have arguments.
Safety to be heard in the bond.
Standard bond is fine, Your Honor, with this.
Defense?
Judge, we'd be asking for a proper bond due to the nature of the charge, and Mr. Weaver is homelessness right now. We would be asking for a dollar bond. Standard bond in this case would be $500. We'll not be able to afford that because he's experiencing homelessness. We believe that would be equivalent to holding no bond, which we don't be appropriate considering the nature of the charge.
State?
Yes, Your Honor. The hesitation from the state is that the security officer at the plaza confirmed that it is an ongoing issue with Mr. Weaver. So it's something that's happening consistently and constantly to the point where it's become an issue.
Sir, I'm going to issue a $1 bond so that you are able to bond out. I'm going to order that you stay away from the Miller Shopping Plaza. I'm telling you, you cannot go within 1,000 feet of that plaza. That's very far away. So don't go into that area. Don't go sit on the sidewalk. Do you understand?
I'm sorry, Your Honor. Is the bond?
$1 bond. I'm ordering a stay away order. He must stay at least 1,000 feet away from the Miller Shopping Plaza, which he has acknowledged. Okay?
That's true.
Thank you. And then we have Michael Valoria. For someone who to sign her name, you'd think. Are you Mr. Valoria?
Yes, Judge.
All right. Do you speak English, sir?
Yes, I do.
All right. This looks like it's a bench warrant for failure to appear on a new driver's license. And then it looks like there's a separate no motor vehicle registration. I think I need to ask if there's any objection to probable cause on that one.
So if I can address the bench, Judge.
I'm sorry?
If I can, sorry, moving it back and forth. If I can address the bench warrant, please.
Okay.
Mr. Valoria says that he was on court on Zoom on his phone, which was permitted for the court that he was in, however, his phone died. So he was present, but his phone died at the time his case was called and a bench warrant was issued. So for that, I would be asking for him to be released on the bench warrant because his failure to appear was not willful. And he did appear, just was not there because his phone died at the time his case was called.
State?
May I ask corrections a question? Corrections, is this the VFOS?
Yeah.
Corrections? Is this the violent felony offender of special concern?
Yes.
And on what case is that? Or what case led to them being classified as such?
No, you will have to pick that up because we don't have access to all those different systems.
Counsel, do you have a fire sheet set out?
No, Your Honor. So we looked him up. We ran his PID here. We looked up his TPO. We can't find any priors. Our standard from the state attorney's office would to have a hold, to ask for a hold on whatever case essentially made by VFOS. Typically in cases like this, like we are advised that they're not eligible for bond of any kind. We can't agree to such, but he would ask for a hold of what made him a VFOS.
Yes, so he does have priors, but they're not recent, and he's not on an open probation. So usually when they're a VFOS, it's because they either violated probation or they violated some community control condition, right? We can't find what probation that is or what community control condition that is.
All right, and corrections, you have no more information?
One moment, Your Honor.
Would you mind repeating, please?
There's no question, I'm just asking if corrections has any more information, because nothing we have signals that he is a VBOS. Do you maybe want to ask your client? Don't have to, but do you want to ask your client if he's on probation or has been on probation in the last few years?
But we would be asking if we could pass this case either for tomorrow so that we can get the national part.
Your Honor, I think the, Mr. Valoria is on probation in Broward.
If I may, Judge, he let me know that he went to the police station to sign up, right? But it's our position that his bench warrant, his failure to appear was not willful because he was in court on his phone, but his phone died.
Okay. All right.
Corrections is almost that he is in probation in Broward. We are required to ask for not release him and to issue a hold for him to be.
And I'm being told by corrections that there is no hold. So if you, right,
I'm sorry, corrections, what was that?
they were saying that you can't place hold on a Broward.
Place the hold on his Broward, on the Broward case.
I don't have a case number.
The judge is that he is not
Okay.
eligible for any bond.
All right, here's what we're gonna do. I can't find at this stage that the state has shown that he is not eligible for bond. That said, candidly, defense counsel, I have someone who failed to appear. While I hear your argument, we can't have a full hearing to determine willfulness. And on top of that, he's arrested for a new charge. And I have to take all of that into consideration along with the base information. So we have two choices. I can reset this to tomorrow and allow the state the opportunity, or I can impose a bond that I think is appropriate based on the limited information I have. I'm inclined to issue a bond. What I would be doing is I would be issuing a bond of $2,000 on the bench warrant and $500 on the no motor vehicle registration.
I'm sorry, Your Honor, we only have one case, the E9E.
Correct, I only have the bench warrant case. I don't have any information about any other case.
It's ending LBE, and it does appear that it is criminal, but he's not held on that. I can't issue a hold on that case and issue a bench warrant. I'm sorry, issue a bond.
You can take him into custody and give him a bond on that case if you like.
That's what I'm gonna do. I'm gonna take him into custody.
Can I have the case number, please?
It's a citation AK9 D as in David, L, B as in boy, E.
Okay, that was Alpha Kilo 9 Delta Lima Bravo Echo.
Yes. So it's $2,000 bond on the bench warrant. It's $500. I said $500. $500 bond on the second case. State isn't evidence of the actual probation case. I can't do my job.
Yes, no, completely get that.
Judge, before we move on, I just wanted to ask, what was the bench warrant that was issued on the other case? Because I don't have a dollar in it.
The bench warrant was initially $1,000.
Oh.
Which case are you asking?
The bench warrant. That's the only
The
one.
bench warrant was originally $1,000, but based on the new arrest and the information with regards to Broward probation, I'm raising it to $2,000.
Okay,
So I've given you my reasoning and my basis for my rule.
thank you.
All right, I believe that completes our misdemeanor calendar, yes? All right, let me say thank you to corrections and the clerk's office staff, also the attorneys. Thank you all very much. We'll be in recess for a few minutes. Thank you, Mr. Interpreter.
Your Honor, you wanted to come back,
Recording
yeah.
stopped.
what, 15?
Back for felonies, I just don't know when we're gonna start.
Okay,
Won't be long.
okay, all right.
Have a good weekend, everyone.
Thank you. We'll go with the record.
Hello. Just a quick question. Do you know if Nicholas Gunther has been seen yet?
She over that ass. But he told me. Yeah, you know, all the reasons don't clap everybody. I think people will pay for it. I would say.
Is everybody ready?
We're ready.
Recording in progress.
Good, I got it. I'll use this one. All raise your hand. Do you swear from the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? If so, say I do.
Hey, excuse me, Judge?
Yes, ma'am.
I'm sorry, I just wanted to ask, have I missed Nicholas Gunther's time to speak?
No, ma'am. We haven't started the calendar yet, unless the case was a misdemeanor or trial.
Oh, so he is on today? I should keep waiting?
Yeah. It's on today and it hasn't been called.
Thank you.
No problem. All right. Good afternoon, everyone. I think afternoon, I'm Judge Natalie Moore. I'll be hearing your case. Let me have the state and defense announce their presence for the record.
ASA Maria Milano for the state.
Defense?
Tamara Gray, Assistant Public Defender.
All right, Ms. Gray, let me let you know we've been having some audio problems today. If you have any trouble hearing, let me know. We'll do the same for you, all right?
Thank you, Your Honor.
Tamara Gray, Ms. Gray. All right, we're going to call your cases one at a time. Everybody has been sworn in. You've all watched a video that goes over some of your rights. We will address those one by one. Unless I otherwise state or there's otherwise argument, I'll make a note that I am going to find probable cause. I've had the opportunity to review some of these forms, but not all. So, Ms. Gray, I'll ask you in each case whether or not you have argument as to probable cause, all right? All right, first case I have is Otis Wakefield.
Otis Wakefield. I'm sorry, Judge. Who did
This is on page 12. My understanding is corrections asked us to call this out of turn.
What's the name? Otis Wakefield.
Well, now I'm being told maybe I'm wrong.
No, I'm asking you, who did you call, Judge?
Okay. See, it wasn't me. All right. Keon Curlington.
Judge, Mr. Curlington refused, reset for tomorrow.
Is this the first refusal?
Yes.
Does the defense want to waive presence?
No, that's the DB present.
All right, we'll recess till tomorrow. Then I have Swingfield.
Mr. Wakefield also refused, Judge, reset for tomorrow.
This is the first one.
First refusal.
All right. Then I have Chester Rebello.
Ward D, reset for tomorrow.
All right, we'll recess this case till tomorrow.
All right.
Then I David Soto.
Soto also refused, first refusal, reset for tomorrow.
All right. The refusal will reset till tomorrow. Then I have Devontae Jackson.
This is Mrs. Jackson. Before you, Mr. Jackson, added charge, boundary violation.
Good afternoon, Mr. Jackson. Do you speak English? All right. Vince, do you have any objection to probable cause?
Stand muted this time, Your Honor.
State, do you wish to be heard as to bond?
Yes, Your Honor. The defendant has multiple open felonies. In addition, he has multiple prior felonies from what I am seeing, over 10 convictions. Your Honor, we would be asking for an elevated bond.
Are you seeking a specific amount?
10,000. He has multiple open felonies.
Defense?
Your Honor, I'd ask if there is a standard bond, that the standard bond be set.
Is he gonna be held on the felonies that he has?
Judge, this is an added charge. So he's already in custody.
And your prior conviction was shown from Mr. Jackson from 2023.
All right. I'm gonna issue a bond of 7,500 on count 1. Thank you, sir.
Judge, are you elevating the bond?
Yes, I'm ordering 7,500.
Okay, Jack.
Lexter Coriolan.
Here, look, you can stand.
Good morning, sir. Speaking, good afternoon, sir. Do you speak English?
You speak English? Oh. That's what the judge was asking.
Judge,
Yes?
Mr. Lexter Carnan is refused, is set for tomorrow.
He's present.
No.
Oh, that's it.
What's your name, sir?
This is the Charles Dennis before you, but the defendant that you called before him, he refused, we set for tomorrow.
All right, so Lexter Coriolan, we're gonna reset for tomorrow and mark as a refusal. And you are Mr. Charles Dennis?
Yes.
And you speak English?
Yes.
All right. Defense, do you have any arguments to probable cause?
Stand muted as probable.
State, do you wish to be heard? Yes, ma'am.
We can't hear.
Apologies. Given that the defendant has picked up 3 felonies in this year alone, with a misdemeanor, and they've all been convictions, we would be asking for an elevated bond.
Defense?
Your Honor, request of standard bond be set, please.
I'm setting bond at $5,000. As a reminder to those watching on Zoom, if you wish to be heard on a case, you can raise your hand to indicate you wish to be admitted to speak, and we will hear from you.
Buenas tardes, todos los que están en la plataforma Zoom que desean hablar, pongan las manitos en el chat y escucharemos cuando el familiar suyo o el acusado esté presente.
Corrections, I'm going to call another out of turn on page 8. I have Mario Antonio Zapata. And then after that, on page 3, I'm going to have Alfredo Fernandez. We have attorneys on both of those cases. Let me wait for Mr. Zapata.
Good morning, Judge.
Hang on, let's wait till your client's here. Ms. Gray, I'm going to unappoint the public defender on this case because private counsel is here on this one.
Thank you, Your Honor. If I may ask, what is the private counsel's name who filed the notice of appearance?
Ma'am, which
Gloria Cancino, we have not filed a notice of appearance as of yet. We just appeared because we were practically hired overnight.
All right, can you spell your last name?
Cancino.
And you'll be filing this appearance?
Yes, we will.
Monday? Okay.
Yeah.
You miss. All
right, Mr. Zapata, you do have an attorney here to speak on your behalf, so let's listen to what she has to say. Defense, do you have any argument as to probable cause?
Judge, Mr. Zapata has a hold for Broward, no bond.
Thank you. Corrections.
Judge, if I may.
You're gonna have to speak into the microphone so they can hear you.
I apologize. No probable cause argument as of right now, given that my first argument is, it's not an argument. Judge, he is not Mario Zapata. His name is Jorge Zapata. He is Mario Zapata's brother. There's an identity switch up that appears to have happened. I brought, in order to prove his identity, his mom, his birth certificate, his ID, and his brother, to prove that who is standing in front of you right now is Jorge Zapata. Jorge Zapata does not have any priors and does not have a warrant case. So my ultimate goal today is just to set a bond on the case of the concealed weapon carry, which is the only one that doesn't have a bond set, or it says to be set. And to remove this warrant case, clarify his identity. And that's essentially my goal for today.
Nate, go on.
So Your Honor, as to the identity issue, because I don't believe that there's any probable cause argument right now, that's not something that we normally handle in felonies. It's something that needs to go through a system when we receive the documents, verify that it's the incorrect defendant, and then we need to have an order signed by the judge to correct the identity. So I'm not sure if the person dealt with this issue before, but we've never had it brought to the bonds hearing. I don't believe that is something that the state is prepared to address today, or that we would ask for to issue.
Judge, just to be safe, I brought the mom. She can be put under oath, and we have the birth certificate and Mario Zapata's passport because they're brothers. So
I can't hold an evidentiary hearing today without witnesses, without the opportunity to give the other side to. So what I'm gonna do today, I'm gonna give your client a bond on the cases that are before me. There is still gonna be a hold in Broward, but what you'll be able to do is set before the presiding judge once the case is assigned, it may be, and you'll be able to seek an evidentiary hearing at that time. It can be expedited, but it can't be done today.
yes, Judge.
Absent an argument for probable cause, do you have any other argument as to the bond amounts?
The only other question I have is the warrant case. Will you be setting a bond on the warrant case as well, or?
That's out of Brown. I don't think I have jurisdiction to do so. So they'll be holding that.
So they will be holding him
For now.
regardless. Okay, understood.
All right. I'm gonna issue standard bond on these counts. So on count 1, it's gonna be 2,500. On count 2, it'll be 2,500. On count 3, it's a misdemeanor carrying a concealed weapon. I'm gonna issue a $1,000 bond. And on count 4, I'm gonna issue a $100 bond. So that one is reduced.
Yes, Judge. And you said 1,000 on the.
2,500 on count 1, 2,500 on count 2, 1,000 on count 3, and 100 on count 4.
Okay.
All right. The hold over, but you'll be able to address that relatively quickly with the presiding judge. Okay.
Yes, Judge.
Thank you,
I'll
ma'am.
do so. Thank you so much. Thank you.
All right. Alfredo Fernandez, if counsel could come in.
Good afternoon, Your Honor. It's no longer morning.
Welcome back, Mr. Fernandez. We just need your lawyer.
Hi, Your Honor. You hear me? Your
I
Honor?
hear you, but I can't see you.
Oh, you want to see me? I'm sorry, Your Honor. I wasn't expecting this. Hold on.
You don't have to come on camera.
No,
if
it's
you
okay. You can see me. I'm just not dressing in a suit or anything. I'm sorry.
All right.
I am not good with the Zoom thing. I apologize. Hold
That's
on.
okay. State your name for the record.
Your Honor, my name is Peter Suarez. I've been retained by the family members of Mr. Alfredo Roberto Fernandez.
So I can acknowledge your presence and recognize that you are counsel for the defendant. At this time, do you have an argument as to probable cause with regards to the plea?
I would not argue anything about the probable cause, Your Honor. I only request that you give us a standard bond, and hopefully we could get him bonded out.
State you wish to be heard on bond?
Yes, Your Honor, this is the defendant that had a DUI from New York 2023. He was convicted guilty. So we would be asking for an elevated bond. Your Honor, the standard bond in this case would be 7,500. We're asking for an 8,500 bond.
Your Honor, if I may say, the DUI, from my understanding, was from 2021, and that was over in New York, not here in Miami, in Florida, and it was a misdemeanor up there, from my understanding.
That's the location matters. They do have concerns, but I think the standard bond of 7,500 is more than enough here. So I'm going to issue a $7,500 bond on count 1.
Thank you, Your Honor.
Thank you all. Have a good morning.
And Your Honor, this is Ms. Gray.
I'm sorry, Ms. Gray. I should have told you there's private counsel in this, so we're going to review from this case.
Thank you.
I apologize.
Thank you, Your Honor.
Thank you. Have a good morning.
Happy holidays to all you, everyone.
Thank you.
Thank you.
All right. We're going to go back now through the regular calendar. The first case I have is Ivis Telephone.
Okay.
Are you Ibis Telephone?
Your Honor, can you hear Ms. Tyrone say yes?
Yes,
Okay, no, couldn't hear. All right, and you speak English?
I do.
All right. Defense, do you have any argument as to probable cause?
Yes, Your Honor, defense has a probable cause argument with respect to the tampering of physical evidence attempt.
Go ahead.
Your Honor, the arrest affidavit alleges that Ms. Tyrone intentionally began stepping on the pipe to break it. There's no indication Ms. Tyrone any time would have known or should have known that item. In fact, was potential evidence. The officer indicates in the arrest affidavit that something from her personal bag. I don't.
All right. State.
We believe that there is probable cause that the defendant intentionally stepped on the pipe because immediately when the defendant was taken into custody, she began rummaging through her purse. The pipe fell, and that's when she stepped on a judge. Given the totality of the circumstances, she was about to be arrested. She was trying to get rid of this judge, given that she stepped on the pipe right after she rummaged through her purse. So we asking you to find probable cause on that one as well, Judge.
All right, I'm satisfied that there's probable cause. State, do you wish to be heard as to?
Yes, Your Honor. We would be asking for an elevated bond. She has a prior felony from 2012 for trafficking in controlled substances, as well as other withholds. In similar cases, Your Honor, because of that, given that it's a related charge, we would be asking for an elevated bond.
And Your Honor, if defense can be heard, that was from 2012. That could have been within 13 years ago or close to 13 years ago. With respect to other prior convictions, I do not see anything as indicated on her CJ now. I will ask if the court will consider either a reduced bond or just a pretrial release.
Does your client have a permanent address where she's staying?
Yes.
All right, for her to pretrial services. The alternate bond on count 1 will be 500. Right. Can I write it? All right, pretrial services on count 2 with an alternate bond of 500. Pretrial services on count 3 with an alternate bond of 250. And pretrial services on count 4 with an alternate bond of 250. I think that's everything. Use corrections. I'll assume. Adriana Butler. You said, did you write the?
Are you Adriana Butler?
All right, Miss Butler.
Morning.
Good morning. Speak English.
Yes.
All right. Vince, do you have any argument as to probable cause?
Yes, Your Honor, I do as to count 2, the aggravated battery, the 4 corners of the 3 pages of the arrest affidavit do not lay any serious bodily injury. There's no indication that a deadly weapon was used. Or no disfigurement.
During the altercation, the victim was punched in the head and face and struck in the head with a glass bottle. State, do you have any arguments?
Yes, Your Honor. Under aggravated battery, we either need to show bodily injury or that the item was an item that can cause bodily injury. In this case, it was a glass bottle. So that part is present. The second part, Your Honor, the victim did sustain a concussion and a laceration. Of course, we don't know at this point if that's going to leave a lasting effect, Judge. So because of that, we believe that in 2 ways the aggravated battery is met and probable.
And Your Honor, just to correct, it says a contusion, not a concussion, not that.
Oh, thank you. All right. Based on the affidavit, I'm going to find probable cause. State, do you wish to be heard as to bond?
Yes, Your Honor. This defendant has a fugitive out-of-state warrant from 2025 that was quashed. However, they are also in probation in Texas. They also have a fraud felony conviction from 2025. and fraud PTI from 2025. So given the recency of priors, we would be asking for an elevated bond. And actually, Judge, excuse me, because they are on probation in Texas, we'd be asking for felony.
Can I?
You can issue.
No.
Not on the Texas case, but what we're asking is that in this case, Judge, she'd be held because of the fact that she's a fugitive in another state. She poses a risk here, Judge.
And Your Honor, this is defense. I'm sorry. I can hear you
Judge.
fine, but with respect to the state speaking, they're going in and out. And I just need some clarification. The assistant state attorney saying that Ms. Butler has an out-of-state warrant from the state of Texas.
The out-of-state warrant was quashed. The state is now saying that she's on probation in Texas. And she's asking for, the state is asking for a fugitive. Can you tell me?
Judge, you can't get a fugitive. Judge.
Yes, ma'am.
Yes, she can't get a fugitive hold. We don't have a fugitive hold for her on the jail card.
I don't think I can hold her for that reason. I
Can't
understand
hold
her argument, but I don't think this court has
Understood. Then we would just be asking for an elevated
Of what amount?
For the robbery, we would ask for the regular 7,500, but for the battery, we would be asking for 8,000.
Defense.
Your Honor, I would request that with respect to the aggravated battery, that Your Honor consider a lower amount of bond. I do understand that Your Honor has found probable cause with respect to the ag battery. In my opinion, I think at most it's a felony battery. So I will ask that the court will give Ms. Butler reduced bond from count 2.
Okay. I think the allegations here are serious enough, and especially in light of the information I've been provided about Texas, I'm going to order $7,500 on count 1, $7,500 on count 2. Ma'am, I'm also going to order that you stay away from the alleged victim in this case, whose initials are MP. Do you understand my instruction? If you get in contact with this person, you can be found in violation of my order. All right, understand? I need you to acknowledge.
Oh, yes.
All right, thank you, ma'am.
I can recognize you. You have.
All right. Next case is Shayla Buckley. All right, we have 2 A forms on this case. We'll address them in turn. The first one is F25-26728. Defense, do you have an objection to probable cause?
I'm sorry, no, Your Honor.
All right, state, do you wish to be heard as to bond? Well, you know what, let's do, is there probable cause? Do you have any probable cause objections to the second case, which ends in 727?
Yes, Your Honor, defense does have an
All right,
objection.
let me hear that argument first.
The response, I'm sorry, Clay was arrested for a burglary to an occupied dwelling. If Your Honor, the arrest affidavit alleges that, first of all, this was a business, and second of all, it's alleged that Ms. Clay supposedly seen on closed circuit TV in an automobile away from this particular business. So there's no indication, first of all, that she entered into an unoccupied business, or no indication that she acted as a quote unquote lookout for the person who actually went inside the business. So my contention, Your Honor, is that it should not be a dwelling. If the court finds burglary, then it should, and most burglary to a business.
Remind me, Ms. Springer, saying dwelling has to be lived in as a personal home?
That's correct, Your Honor. And there's nothing in the arrest affidavit that in fact says that the business owner was also using this address at 5465 as his or her personal home.
So your argument is they should find probable cause only for burglary of a structure?
Yes.
All right, state.
Your Honor, I am reading from Florida Statute 810.011 just to make sure, and dwelling under the statute means a building or conveyance of any kind, including any attached porch, whether such building or conveyance is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied. Apologies, counsel is correct. It has to be lodging there at night, Your Honor. So as to that, we would agree, Judge, we would be asking for the, standard bond unoccupied, structure, Judge.
All right, I agree. I think that Ms. Gray made the right point here, so I'm gonna find for burglary of an unoccupied structure only on that case, so it's a PC to a reduced charge. Your argument has to bond on the 2 counts from the state.
Yes, Judge, we would be asking for an elevated bond, given that the defendant has 3 convictions, that are felonies from 2025, including burglary. So given that this is the same charge, again, Your Honor, we would be asking for an elevated bond.
And Your Honor, most respectfully, I have the Seizures plan. I don't see any convictions for Ms. Bill Clay from 2025.
They're with us. And 1 day probation.
I am checking now, Your Honor. Because I'm looking at her out-of-state priors as well, Judge. I don't see, Judge, the disposition in front of me. However, even if they are with the judge, we are asking for an elevated bond. The defendant has been charged with this same year.
Defense?
Your Honor, I have to, well, first of all, if the court will consider pretrial release either or reduce bond. The court found PC for the burden structure and for cocaine possession of both 31 felonies. The seizure requires from Ms. Blue, Your Honor, indicates that she completed probation. I can't tell if it was a successful or unsuccessful. Oh, I'm sorry, Your Honor. It would have had to have been a successful termination because she was only given 1 day of probation.
All right. Your client has an address?
Yes, okay.
Yes?
38 Northwest on Street. That's right. Sure.
All right, I'm gonna order your client into trial services on case number F25-26728. There'll be pretrial services with an alternate bond of 1,000. And on case F25-26727, will be pretrial services with an alternate bond of 2,500. I'm also gonna order, ma'am, that you stay away from the following address. That's 5465 Palm Avenue in Hialeah. Do you understand my instruction?
Yes.
I need you to answer out loud.
To stay away. Your Honor, did you give the address for 38?
The address is 5465 Palm Avenue.
I don't know. Okay. Is it Sunny State?
Do you understand? I'm sorry, I need you to say yes or no so we can hear you.
Right here, sis. Yes.
All right. Thank you, ma'am. Next case is Linda Carson.
Okay, that's it.
All right, you're Ms. Carson. Good morning, ma'am. You speak English? All right. Defense, do you have any argument as to probable cause?
I'm sorry, Your Honor.
It's okay. Ms. Gray, do you have any argument as to probable cause?
Yes, Your Honor, I have an argument as to probable cause. Again, that the arrest affidavit indicates that this was a cigar store. So it should be burglary to a structure versus burglary to a dwelling.
Stating an objection to that?
No objection.
All right, I agree. I'm gonna find probable cause for reduced count of burglary of an unoccupied structure. I'll also find probable cause for count 2, grand theft in the 3rd degree. State, do you wish to refer this to bond?
We're asking for standard bond on both counts.
Defense?
I would like the court will consider pre-trial release. I don't show for Ms. Carson any prior convictions.
My problem, Ms. Gray, is that pretrial says that she doesn't have a permanent address and I can't enroll her.
Okay, I do see that, Your Honor. I see he's listed as home. Ms. Carson, do you have a permanent address?
State, do you have objection to that?
Your Honor, yes, we would, just because she did pick up 2 charges, Judge, and this person does have priors. We were just asking for a standard, however, given the lack of recency, Judge.
All right, Ms. Gray, do you have any problem with TAP?
Yes, Your Honor, tap.
I'm sorry?
Did Your Honor, do I agree to tap?
Asked if you objected, but either way is fine. You're okay with TAP?
Yes, Your Honor, I am.
All right, I'm gonna do TAP with an alternate bond of 1,000 on one, TAP with a bond of 1,000 on count 2. Ma'am, I'm also gonna order, if you are released, that you stay away from Cuban Crafters Cigars, 7th Street. Do you understand my instruction?
I understand. I need my ID.
I can't hear you because you're not talking to the microphone. I just need a yes or no. Do you agree to stay away and understand my order?
Right, the judge is asking, do you understand her order that she's giving you to stay away?
Yes?
Yes, sir.
All right. And has indicated in the affirmative, stay away from that location, ma'am. Then I marry your Sakura.
So that's it. You the one who make this time.
All right. Can you speak English?
Yes.
All right. Ms. Gray, do you have any objection to probable cause?
No objection to probable.
All right. Court will find probable cause. State, do you wish to be heard as to bond?
We're just asking for standard bond.
Defense?
Your Honor, I don't, that Ms. Sakura, does have a permanent address. I don't have any. Oh, I'm sorry. Your Honor, are we on Sakura?
Yes, ma'am. You're not Miss Sakura?
Person, we need to
Okay.
person.
No problem. We're gonna bring you back when it's your turn. Let's try again.
Are you Miss? Okay, Your Honor, I believe Sakura needs an interpreter.
All right. Assistance of the interpreter.
Yes, Your Honor.
Let's start over again. Good afternoon, ma'am.
Buenas tardes, señora.
Your lawyer has
afternoon.
looked over and agreed, and I have found probable cause.
Su señoría ha determinado que hubo motivo fundado ante su arresto.
State, do you wish to be heard as to bond? My understanding is she qualifies for pretrial services.
Su señoría le está preguntando a la fiscalía con respecto a la opinión de ellos sobre fianza porque ella entiende que usted califica para los servicios de intervención previo a juicio. I cannot hear the state.
I cannot.
It appears that the defendant, although does have an address here, Your Honor, is not originally from here, and additionally, the amount that was taken, Judge, is grave. So because of that, we're just asking for standard bond.
Defense?
Parece que la acusada no tiene parece que tiene una dirección aquí, pero no vive aquí, y debido a que el monto que fue hurtado es grande, su señoría le estamos pidiendo fianza de rigor. ¿Qué dice la defensa?
Your Honor, I will ask for pretrial services. The arrest affidavit does indicate that the respondent does have, does have a permanent address, and I show there's no priors.
All right.
Su abogada está indicando que se indica que usted tiene una dirección permanente, así que usted calificaría para los servicios de intervención previa a juicio.
I apologize. I'm going to order pretrial services with an alternate bond of $2,500.
Su señoría va a ordenar el servicio de intervención previa a juicio, de lo contrario, fianza alterna 2,500.
Ma'am, I'm also going to order that you stay away from 4345 North Meridian Avenue. Do you understand?
North Meridian, Your Honor.
Yes, sir.
También su señoría va a ordenar lo siguiente, que usted tiene que mantenerse alejada de la dirección 4345 de North Meridian, de la avenida North Meridian.
Do you understand my instructions, ma'am?
Señora, ¿es que acaso usted entendió mis instrucciones?
Sí.
Yes, yes.
All right, thank you very much.
Muy bien, muchísimas gracias.
The next case I have is Teresa de Barahona.
Judge, she has the hold for immigration.
Thank you.
You're right, spare home, so we'll need you.
Good morning, ma'am. Good afternoon, ma'am.
Buenas tardes, señora Barahona. ¿Usted necesita los servicios de un intérprete en español?
Sí, por favor.
Ok.
All right. Defense, do you have any objection to a finding of probable cause?
No, Your
State, do
El
you
señor ya le preguntó al abogado de oficio si hallaba algún tipo de defecto en el motivo fundado. Ella indicó que no.
We're asking for standard bond.
Y la fiscalía está pidiendo fianza de rigor en el caso suyo.
All right, with the immigration, Ms. Brady, you have another argument?
Con respecto a la orden de retención de parte del Departamento de Inmigración, le están preguntando a la doctora Gray, el abogado que está a su izquierda, si ella tiene algún tipo de argumento.
Your I do understand that it's reported that she have an immigration hold, but I still ask just in case, for some reason, she is taken into custody that she be released from trial soon.
La doctora entiende que usted tiene una orden de retención de inmigración, pero si por alguna razón a usted no se le lleva inmigración, ella está pidiendo que se le habilite o se le facilite los servicios de intervención previa a juicio.
All right, I've been corrected, told that I could order her in, but I'm not going to do that in this case. I'll issue a reduced bond of $1,000.
Sé que los carceleros me indicaron que yo puedo ordenar el servicio que se le rinda a ella, pero no lo voy a hacer en este caso. Sí le voy a reducir la fianza a solo $1,000.
Ma'am, I'm also going to order that you stay away from 7111 Southwest 142nd Place.
102nd Place.
142, yeah.
También, señora, le voy a ordenar que usted se mantenga alejada del 711 de la 114 Place del Southeast, del sureste.
Do you understand my instructions?
¿Usted me ha entendido mis instrucciones, señora?
Sí, señor.
Yes, ma'am.
Thank you very much.
Muchísimas gracias.
Thank you. Thank you. I have Elizabeth Perez.
Added charge. ASA on behalf of the state.
All right. Just announce.
Me.
I'm sorry, I need to say your name again?
Yes, ASA on behalf of the state.
Oh, okay.
Sorry. So I wanted
Got
to
it. All right. We have a new assistant state attorney on the case who's been sitting here full time. All right. Defense, do you have an argument as to probable cause?
I do, Your Honor. Count one alleged first degree felony, grant.
I'm sorry, Ms. Gray, we're having trouble here. It's not your fault. Could you try again?
Ms.
Yes.
Gray, does she speak English?
Pause argument. I'm sorry. Do you need an interpreter?
No.
Okay.
Okay.
No, does not need an interpreter.
Okay. Your argument is to probable cause.
I do, Your Honor. I do have an argument as to probable cause, at least with respect to it indicating that it's a first degree felony grand theft automobile.
Go ahead.
The arrest affidavit, Your Honor, does not indicate that this particular automobile is over a certain amount, at least with respect to the 2 pages of the arrest affidavit. So I would say, Your Honor, with respect to a third degree felony of grand theft of an automobile.
State, on what basis is this F1? On the way.
Your Honor, the state was seeking an interpretation of the April as to actual value.
So it drops to second degree felony or third?
Your Honor, third degree felony.
Thank you.
Yes, Your Honor.
All right, I'll find probable cause for the third degree felony. Dave, do you wish to hear this with bond?
Your Honor, she only has one prior conviction. I understand.
And Your Honor, Her conviction is for a misdemeanor from it was out 2020.
I'm also looking at, she's apparently, corrections help me out here, out on bond on.
Yes, Your
third
Honor.
degree felony.
Yes, Judge, already been held on those two TCs.
So
there's-
she'll be held on those. I'm gonna issue a $5,000 bond on this count. Okay,
Your Honor, if I may ask, corrections, can you give me the case number that she's out on bond for? I believe that. Ms.
She's not
Perez
on bond.
is
She has two TCs that she's been held for. F24022920 and F241495.
Thank you.
all right. Thank you. And I have Mauricio Castro Ortiz.
$5,000, Judge, for Ms. Perez, correct?
I'm sorry, you said found out?
5,000. For Ms. Perez, the bond was 5,000.
Oh, yes.
And Your Honor, I will be addressing the rest of these is gonna address all of them. I was not able to address part of it. Can you favor, please? Retrial motion, state.
All right, Mr. Castro Ortiz, do you speak English?
Your Honor, he was not. He-
All right, so we need the assistance of the interpreter. Good afternoon, sir.
Buenas tardes, caballero.
Ms. Gray, do you have
Good
an argument
afternoon.
for probable cause?
Your Honor, I don't have an issue as to the probable cause. However, I do have an issue with the, it being as a life felony. If Your Honor could use.
I'm sorry, Ms. Gray, no problem with the probable cause. However, you did have an issue with.
The listing of the offense as a life felony.
Ok, su señoría le acaba de preguntar a su abogada si ahí tiene argumento en contra de motivo fundado. Ella dice que no tiene argumento en contra de motivo fundado. Sin embargo, lo que sí tiene un argumento es de que esto no es una acusación que usted confrontaría a cadena perpetua.
You don't believe that the charge as it is with a child under 12 is life felony?
No, Your Honor, I showed that for L&L molestation of a child under 12 and a defendant being older than 18, that it should be second degree.
Ella está argumentando, su abogado, de que la juez le preguntó si ella no cree que esto es cadena perpetua. Y dice no, porque was the child under 12?
The child under 12, adult under 18.
I'm not understanding anybody, and I apologize.
No, I'm sorry. It's a child under 12 and the offender over 18.
Under 18?
The child under 12
Ajá.
and defendant over 18.
Oh, that's what I thought. La menor o el menor tiene menos de 12 años de edad y el acusado tiene más de 18 años de edad.
¿Sí?
¿Qué dice la fiscalía?
Is defense counsel asking for probable cause for concern included? Is that what defense counsel is asking?
I think defense counsel is saying that the charge as stated is not a life felony.
Is there being made as to? I've never.
The statute charged is 800.04 subsection 5B. Is that a life felony? Thank you. For the record, I need to.
Su señoría está preguntando si la acusación por el estatuto de dicha acusación califica para cadena perpetua. Eso le preguntó a la fiscalía.
All right. Counsel, when I look at the statute, and feel free to correct me because I'm working on a computer here. Subsection 5B says that offender 18 older commits lascivious molestation against a victim less than 12 years of age commits a life felony.
El señor le está preguntando a su abogado de que la corrija si acaso ella está equivocada. Por el número y letra del estatuto dice que si la conducta lasciva y lujuriosa del acusado mayor de 18 años de edad y la menor o el menor de 12 años de edad califica entonces para cadena perpetua.
That is what I'm saying as well, Your Honor, so it is a life felony.
La fiscal adjunta está de acuerdo, así que ella concuerda. Esto califica para cadena perpetua.
Your Honor, what I was looking at respect to Florida statute and reading, it says an offender 18 years of age or older who commits lewd or severe molestation against a victim 12 years of age or older, so that means a person 12 years or older, but less than 16 years of age commits a felony of the second degree.
Right, but your client is over 18
I agree with that.
and the alleged victim is under 12.
Your Honor, my arrest form says that she is.
I'm sorry, Tamara, that she is 12?
I'm sorry that yes, the alleged victim is 12. Not under 12, but is 12.
Su abogada está leyendo que en el informe de arresto, pese que indica que usted tiene más de 18 años de edad, indica que la víctima tiene 12 años de edad.
All right. Ms. Gray, I think we may have an argument. I'm gonna take a few minutes. I've been asked to go and handle the juvenile now. That will give sides the opportunity to this issue. You need to take a look at this and make your argument. In the interim, be in recess. Does anybody know how long we're gonna do? 10 minutes and we'll be back on the record, okay?
Su señoría está pidiendo un break. Oh, he's gone.
Recording
All right,
stopped.
recess for 10 minutes. I'm gonna ask the parties to do the research on this issue and then I'll return.
Recording in progress.
All right, are we ready to go back on the record? All right. Ms. Gray, you ready?
Get ready. I'm
All right, take your time.
come back in and bring Mr. Castro D. Mr. Ortiz, interpreter? Interpreter? Oh,
Yes.
yes, we have the interpreter here, Mr. Castro Ortiz.
We did, and back on the record, all parties are present. We were in the process of having an argument with regards to the probable cause. Did you review this?
I did, Your Honor. Apologies earlier. I did not understand if a probable cause argument was being made. I understand that it was. Counsel is correct that the victim was 12 years of age. When the victim is 12 years of age or older, it is a second degree felony. We would be asking that you find probable cause on the lesser included judge. In addition, we have passed you the stay away order and a pretrial detention motion.
Tras postergar el caso, la fiscalía tuvo la oportunidad de repasar el informe de arresto y determinaron que sí, que la víctima tenía 12 años de edad. Así es que van a hacer una enmienda de un delito mayor de primer grado con posibilidad de cadena perpetua a un delito mayor de segundo grado, pero está pidiendo que haya una vista de retención en contra suya.
And you did you say that they're filing pretrial detention motion now?
We can, Your Honor, and I can make the argument.
All right, let me state on the motion. Well, first of all, I'm gonna find probable cause for the molestation of a child under 12, but I'm going to acknowledge that it's an F2. A second.
Ella va a determinar que hay motivo fundado ante la acusación, pero está también haciendo los apuntes de que es un delito mayor de segundo grado.
All right, you're from the state because you're seeking pretrial detention, and then I'll hear from defense.
Yes, Your Honor. Under Florida statutes 907.041 subsection B, 4, we are allowed to seek pretrial detention whenever a crime qualifies as a dangerous crime. The dangerous crimes are outlined in statutes, including lascivious molestation, in the presence, let me read it directly. Lewd, lascivious, or indecent assault or act upon or in the presence of a child under the age of 16 years is a dangerous offense. In this case, as Your Honor has noted, the victim was under 16 years of age. The victim was 12. We are allowed to seek pretrial detention given that the statute qualifies it as a dangerous crime. And we ask that Your Honor hold the defendant no bond and then
And Your Honor, being
Ms. Gray, if you
I'm sorry.
Okay. La fiscalía está pidiendo y está explicando que la vista o la detención para una vista de detención le califica de acuerdo a los estatutos del estado de la Florida, donde califican la conducta lasciva y lujuriosa o agresión a un niño o niña menor de 16 años como un crimen peligroso. Y en este caso se determinó que la niña o niño tiene menor de 16 años y por ende están pidiendo que se le detenga y por eso ellos tienen la potestad de hacerlo.
All right, Ms. Gray?
Yes. Your Honor, I am physically here at TGK, and the state is there at the Richard Gerstein building. I have not received a copy of an actual motion, in which the state is asking for pretrial detention, of which I would argue that for purposes of due process, Your Honor, that I and my client are entitled to get that motion and prepare for that particular motion. I will ask that at this point in time, Your Honor, that the court, one, either set bond as a second-degree felony, not a life felony, or consider at this point some form of release that does not require Mr. Castro Ortiz to post.
Right.
To post what? To post what?
Go ahead. Go ahead.
Oh, I didn't hear the last part. To post what?
Any sort of release that would not require Mr. Castro Ortiz, Your Honor, to have to post the bond, or if the court determines the bond is appropriate to set any bond amount. I don't know what the standard bond would be, Your Honor, for the second-degree felony.
Okay, su abogado está indicando que ella y usted están ambos, usted está detenido en el TGK y ella está trabajando en el TGK y que la fiscal adjunta está en el Palacio de Justicia Richard E. Gerstein y así ella no ha tenido la oportunidad de utilizar el proceso debido para determinar si hay motivo fundado ante dicho pedimento. Ella le está pidiendo a su señoría que le imponga fianza por un delito mayor de segundo grado, que le imponga la fianza de rigor si es que acaso le exige imponer fianza.
If I could
Give me one second. My understanding of this statute is that I can schedule a hearing within 5 days of the motion.
Según yo entiendo, yo puedo hacer una vista.
For detention.
Ella puede determinar una vista para determinar la retención o detención.
Does anybody disagree with that understanding of the rules at this stage?
¿Hay alguien que está en desacuerdo?
Your Honor, I don't disagree. I don't have that in front of me, but if Your Honor is going to hold the hearing in 5 days, it would actually be held without release, as he's not entitled to release, given the charge for the statute.
Dado la acusación, la fiscal no está muy segura, pero si usted tiene 5 días para determinar la vista ante dicha acusación.
Ms. Gray?
¿Qué dice la doctora Gray?
Your Honor, I disagree on the date of the filing, and I don't know when the state is going to file that motion, that a court can hear that motion within 5 days of the motion.
And Your Honor, just for the record, we have these hearings every single time in bonds, and they are granted. Counsel is aware of the statute. The Public Defender's Office is aware of the statute. We do these every single weekend in bonds, and they are granted us having to hold a hearing. But in terms of notice, these dangerous crimes are brought up often in every single bond.
I agree.
La fiscal
But
adjunta
I
está,
think-
está
Sorry.
indicando que ellos sí están en la potestad de hacer dichos pedimentos y que esto se hace a diario en las instrucciones de primera instancia y que no hay necesidad de previa notificación.
I'm reading the statute. Ms. Gray has raised the fact that she has not seen your motion. I think that it's very clear in the statute what I'm allowed to do.
Su señoría está leyendo el estatuto y aunque ella está de acuerdo que la doctora Gray no ha leído el pedimento, ella entiende cuál es el propósito y la lectura de dicho estatuto.
The statute specifically says if a motion for pretrial detention is required, the hearing must be held within 4 days of the first appearance hearing, which is today.
Y específicamente dice el estatuto que tienen después de la vista de hoy 4 días para ser ventilado.
It says that the state attorney must file that motion and that the defendant may be detained at completion of the pretrial detention hearing.
Dice que la fiscalía tiene que presentar el pedimento y que el acusado se le va a retener hasta que se conduzca dicha vista.
So I am making note of state filing the motion.
Estoy denotando que la fiscalía presentó el pedimento
I'm making that Ms. Gray would like time to review the motion, and she is entitled to that time.
y la doctora Gray tiene tiempo ahora para leer el pedimento y se le está otorgando el tiempo.
The state must set a hearing on this case. Can you give me a date in front of the presiding judge?
¿Para cuándo quiere la fiscalía el pedimento?
Okay, so no, this order that has been handed to me as a proposed order specifies that the defendant would be held in custody, which is what I just pending a final hearing on trial detention. It requires that I find that the defendant has been charged with a dangerous crime, which I have already found, that the offense is a capital felony, life felony, or first degree, and that there is probable cause to believe the defendant committed the offense. I don't believe I can find all 3 of those things. Because I
Sí,
cannot
le acaban de dar
find
una
this
orden.
capital felony, life felony, and first degree.
Yes, so, but it is under subsection B4, which is one of the dangerous.
Not what your order says.
That is what it says,
No,
Judge?
it's not what the order says. And I can't say it does not the actual findings of this court. All right, I'm going to require the court's office to set this hearing Monday.
Van a requerir que se haga el pedimento el día lunes.
And Your Honor, if there's a gentleman in the courtroom speaking, we cannot hear.
I'm sorry, the clerk is giving me procedural knowledge. I'm not sure why if I order it to be set for Monday, it can't be set for hearing on this.
If you said it, no bond.
Judge, are you gonna hold him no bond?
I'm trying to make that decision. I apologize. I wish that I could do it faster, but I need to understand what's legal.
Okay, you grant the motion, then it will be set for the pretrial detention hearing Monday. Now, grant that motion, most people is hold no bond and the defense to set an Arthur hearing for that.
To provide you the statute, because I know that the issue is what the order is stating, the light felony or the capital felony, but under subsection B of Florida statute 907.041, if a person is arrested for a dangerous crime, they may not be granted non-monetary pretrial release at a first appearance hearing if the court has determined that there is probable cause to believe the person has committed the offense. And the dangerous crime here is lascivious acts upon or in the presence of a child under 16 years old. And I believe Your Honor has.
Okay. I am acting this order because I do not think the proposed order that you handed to me reflects my rule. But I am going to rule as follows. I am ordering that the defendant be detained in custody pending a final hearing on pretrial detention. I have determined that the defendant has been charged with a dangerous crime as defined in 907.041(8)(b). Is that correct? And that there is probable cause to believe the defendant committed the offense. Furthermore, the final hearing shall be held in a court of trial jurisdiction within 5 days of the motion or of the date of taking the defendant into custody, whichever is there. So it is a limited finding. I am not making anything other than that. This will go before the judge very quickly. It will be set on Monday, which is less than 48 hours.
Ok, señor, su señoría está tomando una determinación limitada. Está determinando sí que fue un delito peligroso que usted cometió y sí hay motivo fundado para ello. Está concediendo los 5 días para presentar el pedimento. Sin embargo, este pedimento se celebrará el día lunes, que es dentro de menos de 48 horas.
Mr. Markey, I apologize. That was terrible of me to give you all that at once.
So I just need a little bit of clarification because my understanding is that as of now, the state has not filed the motion for pretrial detention.
No, ma'am.
The state has not filed the motion for pretrial detention.
They have filed the motion.
They have?
Yes, but I am not going to hold that hearing today because I agree with you that you are entitled to review the motion, to have time to speak with your client and prepare for such argument or hearing. So what I am is that hearing occur as soon as possible and within 5 days of first appearance. And I've set it for Monday morning so that you have time to motion, speak with your client, perhaps speak with the state, and make a determination. I found that there's probable cause that your client committed the outlined crime. It's the reduced crime. I agree with you that it was a second-degree felony, but I do think that it's delineated here as a violent offense. And so because of that, I do think that I am in my rights to hold him so that hearing can be held. Do you disagree?
Su abogada apenas está tratando de confirmar si es que acaso la fiscalía presentó el pedimento o no. Su señoría le ha indicado que sí, que el pedimento fue presentado y que ella va a tratar de que se le celebre a usted la vista tan pronto como sea posible. Indicó que serían 5 días o menos. Sin embargo, de nuevo reiteró que sería para este lunes, que serían menos de 48 horas.
You know what? Let me ask you this, Ms. Gray. Would you object to resetting this case to tomorrow so that the court has adequate time to review the statute? You have adequate time to review the statute.
To review these, well, I was about to ask the court the question specifically, or the state the question specifically, because the sound is going in and out. Upon what basis of the pretrial motion detention statute is the state relying on if in fact this is charged with a second-degree felony? It does, and my understanding is that it is a conjunctive test, so it must meet the specific level of felony and.
Okay. And Ms. Gray, I think you're making a thoughtful argument that requires some review. But I don't feel like any of the parties present today, the court, the attorneys, has enough clarity. So what I am asking is, do you object to resetting this hearing 24 hours till tomorrow morning? I will be the judge here tomorrow, and we will have a full argument as needed and we will all come aware of the statute and understanding what the requirements are.
And will the matter, if Your Honor hears it.
I'm sorry?
If Your Honor hears the matter tomorrow, will it also be scheduled for the actual hearing on the pretrial detention motion in Judge Hirsch's division?
It depends on what I rule. If I rule that a hearing should be set, then yes, it will be set for Monday. If I rule there is no entitlement to pretrial detention, then I will set bond. What I am not inclined to do is have a full hearing. So either I will rule that there is no entitlement to pretrial detention and set bond, or I will state is entitled to file its motion and have a hearing, and you will have that hearing with Judge Hirsch on Monday or Tuesday.
All right, you never, I'm not on Zoom, but if the ASA in court gives me his or her email, I will send up my email so they can send to me a copy of the motion for pretrial detention.
Yes, definitely. And to answer your question, counsel, that was under subsection B. So it's 5B. Subsection 5B is what allows the judge to grant for it.
So I am signing an order at this time. I am setting this case to tomorrow. All parties will go back and do the research that is necessary and state. I would urge you, if you feel that you have not filed the right motion, to file a motion pursuant to whatever statute it is. If it's this one, that's fine. If it's not, I want there to be a clean record of specifically what you're seeking. I will educate myself, Ms. Gray. I'm confident that you'll come back and know exactly what your arguments are. I will not have a hearing, an evidentiary hearing, or other hearing. That will be for Judge Hirsch. I will either rule that there is no entitlement to pretrial detention and set bond, or I will rule that you are entitled to your hearing on your motion and set hearing. And since all the parties are okay with that, that will be the order of the court. So I've already found probable cause as to the felony of the second degree. I am resetting this case for hearing until tomorrow.
So Judge, for PCH for tomorrow?
Correct. No, not for PCH. I am just resetting.
I need a reason to put on the jail card for a judge.
For judge. Like that, I'm the judge.
Señor, le van a volver a traer mañana, pero mañana es solo para determinar si hay necesidad de una vista el lunes. Ya su señoría determinó que hay motivo fundado ante su acusación y le está pidiendo a todas partes, inclusive a su abogada, la doctora Gray, que haga indagaciones necesarias.
So we will address your case again tomorrow, sir. Your lawyer is doing a very good job arguing for your rights.
Nosotros vamos a lidiar con su caso una vez más mañana. La doctora Gray, su abogado, está abogando por usted y está haciendo un trabajo sumamente bueno.
And the court wants to make sure that its ruling is proper under the law as we have it.
Y este tribunal quiere determinar que la ley se está aplicando como debe de ser.
So we will all meet again tomorrow and determine what steps should be taken on your case next.
Mañana nos reunimos again, de nuevo y vamos a determinar cuáles son los próximos pasos.
Thank you all very much. We'll move on to Dalvin.
Gracias a todos.
All right, you're Mr. Say?
Are you down with the safe? Okay.
All right. Speak English?
Yes.
All right. Any arguments to probable cause defense?
No, Your Honor.
I'll find probable cause based on the allegations in the affidavit. State, do you wish to be heard as to bond?
Yes, Your Honor, we'd be asking for an elevated bond, given that the defendant has 2 felony convictions from 2021, in addition to other convictions from 2017.
Your Honor, unless those convictions are on the state, the procedures prior to that do not show that Mr. Say has any conviction. So
Have an education withheld for camping.
He has one out of state, Your Honor. He has a conviction for battery, and he also has other felony charges such as burglary.
What years?
Out of state. For the battery conviction, it's a 2021.
Defense?
Your Honor, well, for the battery, if it's out of state, I will just argue because I don't know whether that out of state is a felony or misdemeanor. But I will ask if the court will consider either release pretrial services or maybe even tap, I'm sorry, Your Honor, I will take that pretrial services request back because I see that Mr. Safer is homeless. But I will ask, we'll consider release to the alternative program.
Your Honor, the defendant was on probation for 10 years for being out of state. And for out of state.
Okay. Looking at the allegations in the affidavit, I'm not gonna order tap on this case, but standard law is sufficient. So I'm gonna order one count one, 2,500, count two, 500, and count three, 250. I'm also gonna order, sir, that you stay away from Yennefer Machado Valle and 2320 Southwest 154th Circle, number 7. Do you understand my instructions?
Yes.
All right. Thomas Jones.
Your Honor, was way in.
You what? Judge, what was the bonds for Mr. Dalvin side?
You have a seat.
2,500 on count 1, 500 on count 2, and 250 on count 3, all with state.
Mr. Jones is out on probation on 2 cases, F-25, 23503 and F-25, 21687.
Defense, any argument as to probable cause on the new charge?
Your Honor.
All right. I'm gonna find probable cause for all 3 counts. State, do you wish to be heard?
Yes, your defendant has 16 prior convictions, only starting up from 2018 all the way up to 2025. So we do understand that the defendant is homeless. He is not only charged with trespassing. We would be asking for an elevated bond.
Defense?
Your Honor, I will set standard bond a lower fee schedule per se.
I'm gonna issue standard bond on these counts, and I'm gonna issue the felony hold, so he's held on the probation cases. So it'll be 2,500 on count 1, 500 on count 2, 500 on count 3. I'm also gonna order, sir, that you stay away from this address, which is 1664 Alton Road on Miami Beach. Do you understand my instructions?
Yes, ma'am.
All right, you'll go see the judge who is presiding over your probation cases, and you'll talk with that judge, okay?
Okay.
Thank you, sir. Sorry. Then I have semblance. Anybody know this morning? No? Mr. Lentz, I saw you this morning, right? And did I give you a bond in those cases? I did. All right. Defense, do you have any objection to probable cause? Ms. Gray, I think I lost you.
I'm sorry. No.
That's okay. All right, I'm gonna find probable cause on all 4 counts here. Corrections, do you have notes on what I issued this morning?
Yes, Judge. Receive a $250 bond on this traffic.
And it was just 1 citation?
Yes.
All right, defense, state, do you want to be heard as to a bond?
Yes.
Open felony in Broward County and has an open warrant for that felony in Broward County. He also has a 2025 open case in Broward County for stalking and extortion and threatening. We would ask for an elevated bond and GPS.
Defense?
Your Honor, this is for the court to consider a reduction on amounts and possibly consolidate any of the other bonds, given that this is one alleged offense that happened on December 2025. Mr. Blunt also invited Your Honor that he is employed.
He is what?
He's employed.
My way to work.
I'm gonna issue bond $1,000 on count 1, $1,000 on count 2, $1,000 on count 3, and $500 on count 4. All right. I believe there's also gonna be, he's gonna be transferred to Broward or held for the Broward that right, corrections?
When he closes current cases here.
So you'll address this case here and then you'll go to Broward, okay? All right, yes, sir. DeVarius Wright, are you Mr. Wright, sir?
Mr. Wright is out on felony bond judge on 2 felony cases.
Defense, good for probable cause?
Yes, Your Honor, I do have the issue with respect to probable cause, just in terms of the way that the arrest warrant reads as a second-degree felony. If Your Honor looks at that particular statute, it has to be 3 or more retail theft offenses within 120 days.
Arrests or convictions?
The way this statute, excuse me, Your Honor, it doesn't require conviction. The way that the statute says offense, pull it up. I saw F258686 that alleged incident happened on 7. F2519.85 that incident happened on March 18th, and then the case that's before Your Honor. But I don't have anything happen, any 3 or more retail thefts within 120 days. One of them.
I'm so sorry, I'm not understanding your argument.
Okay.
It looks like you're arrested on 3 separate petty theft counts plus this one.
So Your Honor looks at the arrest affidavit that was filed in 26734. It shows second degree felony, retail theft, multiple thefts of items.
Right.
And if Your Honor looks at statute 812.015 8 paren as in Frank, it means that a person who has 3 or more retail thefts within 120 days.
And the 429 arrest is not within 120 days? Is the argument.
I'm sorry, for 20.
Right. There are arrests on 429, 12-2, and 12-12. Oh, and 12-11.
And they would not be 120 days. Because 120 days would be 4 months.
And then state?
Right, so, very much.
So we know that 2 occurred in December, same location, and I'm.
Let's not, I'm not even confident it can be charged the way it is charged. I'm gonna find PC for the 3rd degree felony. But I do think that we're gonna have to talk about bond because it seems an elevated bond would be appropriate here. It also looks like he's gonna be held because he's out on bond in 2 other felony cases. So let's focus on that argument. State?
Yes, Judge, we're asking that he be held on the felony bonds, the current felony cases he currently has, one of them being F19-02165. He also has, of course, the other case from the same location. We are asking for a stay away order and for you to issue standard bonds on these cases, given that he will be held on felony bond.
Defense?
So I ain't heard partial state was saying, and forgive me if I'm repeating anything that the state said. Your Honor, with respect to M2526734, I'd ask if Your Honor would consider the bond amount on the standard bond 3rd degree felony, and I'll make the same argument as F2526733. Mr. Wright also informed me, Your Honor, that his father recently passed away, so he is asking for some form of to report to attendance. I personally confirmed the information relate to the court as Mr. Wright has informed me.
Okay. Looking at the cases that I have before me as well as the criminal history, I'm going to have held on the two cases where he's out on bond. You'll go back before Judge Marion. I'm issuing a $5,000 bond in case F25-26734 with a stay away order. I'm also issuing a $5,000 bond in case F25-26733 with a stay away order. Sir, I'm going to order that you stay away from the BJ's on 6th Avenue. Understand my instructions?
Yes, ma'am.
All right, you're gonna go see Judge Marion. He's gonna talk with you about your cases, okay?
All right.
Thank you, sir. Have a good morning, afternoon.
Yeah, yeah.
Michael Williams,
That's about it.
thank you. Brian Lackage,
Your Honor, this package is full of.
Vince, do you have any arguments to probable cause?
No, Your Honor.
This is apparently a domestic violence case, is that correct?
It is, Your Honor, but it's a felony, so we hear it. Battery by strike.
All right, Vince, do you have any arguments to probable cause?
Your Honor, just specifically with reference to page 2, this being conclusory as to the last sentence where it says Mr. Lackage created a risk of great bodily or impede Ms. Lackage's normal breathing. My argument, Your Honor, is that that's conclusory.
Well, the charge here is battery by strangulation. I don't think that there necessarily needs to be great bodily harm on that charge, does it? I don't think there does. So I'm gonna find probable cause in this case. Let me hear state as to bond.
Your Honor, we're asking for an elevated bond of 7,000. The standard is 5,000. It does have a prior domestic violence injunction. It is from 2013. However, the allegations here, I'm sorry, domestic violence case, not
Same victim?
I cannot see that, Judge, because it's from the state.
All right. I can't see the alleged victim on the case, but I do take note of your argument. Defense, do you wish to be heard on the bond?
Your Honor, did the state indicate that that 2013 case was no action on the cross?
The state indicated that it was injunction.
I corrected myself, Judge, when I misspoke. I stated that he had been charged out of state for 2013 domestic violence. It was not an injunction.
Okay, so it was an actual arrest.
It was an actual judge. This position should not come up because it's not a state judge.
All right. Defense?
Your Honor, I'm sorry, did the state say 2013 it was not an injunction? But I was just asking basically what was the end result of that 2013 case?
They don't have that information. It doesn't show.
Okay. So, Your Honor, I will argue that since that information does not show that Mr. Lackage was on probation for the 2013 case, which we 12 years ago, so if Your Honor, at this time will consider release to pre-trial. Other than the 2000 case of which the state just mentioned, I don't see any other priors for Mr. Lackage. His arrest affidavit does show that he has an occupation of an aircraft technician. I will ask that the court at this time will consider release to pretrial service with an alternate law.
I don't think trial service is appropriate and doesn't qualify. I'm going to issue a $5,000 bond on this case. So I found probable cause, $5,000 bond on count 1. Sir, I'm also going to order that you stay away from JL, the victim, the alleged victim in this case. Do you understand?
I understand.
If you bond out, I'm going to order that you not commit any other crimes, that you not possess any illegal narcotics, that you not possess a firearm, weapon, ammunition, any kind. Do you understand?
I understand.
All right. I'm going to order that you stay away from JL. That means you cannot go within 500 feet of her house, close to her vehicle. You cannot go to where she works or to her home. I understand you lived with her prior to this arrest.
Yes.
I will allow you to go back to the house one time in the presence of a police officer to collect your things, but you must go in the presence of a police officer, otherwise you risk being arrested again. Do you understand?
I understand.
You are not to have any communication with her, no text messages, no emails, no talking to her, any type of social media, and do not have anybody else contact her on your behalf. Do you understand all of my instructions?
I understand.
All right. Do you have any children in common?
Can you repeat
Do you have children in common?
Yes, we have one 10-year-old.
The child's been working with JL for this time. All right, thank you very much. Have a good afternoon.
You as well.
Great. Devin Bree.
Good morning.
Here, Devin.
Done.
All right. Good afternoon, Mr. Green. Since have you had the opportunity to review the form for probable cause?
Your Honor, I have had enough to review the arrest affidavit, and I do not have an argument as probable cause. Your Honor, Mr. Green is asking to go to the mental health hospital. Not sure if he goes as though he Baker Act or he just on me.
I'm being told that I have to ask if Mr. Green has insurance.
No. Yeah.
I'm sorry, I can't hear you, sir. Not your fault. The microphone's been bad all day.
Sunshine.
One more time, I'm so sorry.
Sunshine Health.
You have health insurance, Sunshine Health.
Yeah. I'm here on verb. So against.
Ms. Gray, what is it you're asking this court to do?
So, Your Honor, Mr. Green is asking to be taken to the hospital. I have not had an opportunity to get into much detail with him in terms of whether or not he feels as though he's a danger to himself or others. With respect to the arrest affidavit, Your Honor, I have read the arrest affidavit. I do not have an argument as to probable cause, but I will ask the court to read page 2 of the affidavit, the very last sentence.
I did see that.
If the state could.
Go ahead.
Your Honor, you could reset this case for corrections to determine whether they identify a mental health concern for the defendant, but we should not be releasing the defendant to the public. Additionally, Your Honor, the defendant has multiple prior felony convictions, so we would be objecting to the release, and we would be asking for an elevated bond.
So, Your Honor, I'm not asking for release. I'm asking that this gentleman just be taken to a hospital to undergo a mental health evaluation. Mr. Green has indicated to me, Your Honor, that he felt so presently right now that he is a danger to himself or others.
Okay. This court does not have the capacity to order him Baker acted at this stage, but I do have the capacity to reset this case to allow corrections the opportunity to speak with you, Mr. Green, and help you get the help that you need. So what I'm going to do right now is I'm going to reset your case in 72 hours. So for Tuesday morning, can I do that?
He'll be reset day for day, Judge.
Tomorrow. So we're going to reset for tomorrow. So you're going to talk to the people at corrections. They're going to figure out what you need. And if nothing else, you're going to come back and see me tomorrow, or you'll be in a hospital by then. Okay?
Judge, who will you speak to, Judge?
I can't answer that question for you right now, but if nothing else, you're going to see me tomorrow, and Ms. Gray's going to help you and get you figured out, okay?
And also 8 pieces in the breakfast.
Judge, are you setting the bond for this case?
No, I'm going to reset till tomorrow.
If every pieces, then that's all I.
Wait, you said
Yes.
okay.
So I'm resetting at the judge's discretion. Corrections is going to speak with you.
Judge, what will you want corrections to let him know? What is it that he needs to know from corrections? He's here on a battery by a Leo, a correction officer. So what is it that he needs? He was in here also for an assault. He was given a bond of $250 for that case.
That's right.
My understanding, and please correct me if I'm wrong, is that corrections can. Okay. Ms. Gray, I'm saying it's on you. You're going to have to figure out if they can find benefits in bed for him. I am not in a position to determine his mental health status today at this hearing. The court has no basis to make that determination.
Correct, Judge. So bond either has to be set or the PD has to see if the defendant has hospital benefits to be
So Ms. Gray, do
hospital.
you want me to set a bond for your client in light of all this prior to history? Or do you want me to reset this tomorrow for you to figure out what steps you can take?
I'm asking Your Honor to give him a bond for the case for today.
That's a different request, so let's bring it back.
Okay.
Bring that, okay, you need further. Come on, sir. Not you.
All right, Mr. Green, your attorney has asked that I set a bond in your case, and I am to do that. I have reviewed the allegations in this case. I'm also aware of your prior offenses, and I'm gonna set a bond of $10,000.
That's $100 bond.
I'm setting a bond of $10,000. That's what I'm gonna do, and then your lawyer is gonna talk with you about your options going forward.
Did you? Yeah, Your Honor, just a little bit of clarification. Did Your Honor say 10,000 or 1,000?
10,000.
So Your Honor, I said the court said standard bond, which I believe is 5,000.
I don't think standard bond is appropriate in this case. I did make a review of the A form and the prior history here. I'm noting your client was in custody at the time of the alleged violent action.
There's cameras. It's fine. There's cameras.
Sir, you have a great lawyer doing a really great job defending you. You shouldn't talk to me. You should talk to her and let her do her job. I'm also seeing the history and the amount of times that your client has been sentenced pretty consistently over the years, and that's the basis of my finding. So, Xavier Johnson.
That's okay.
Come on,
You, Mr. Johnson? Your Honor, Mr. Johnson is present before the court, and I do have a probable cause argument.
Go ahead.
Your Honor, the arrest affidavit alleges as to count 1, battery on a person 65 years of age or older. The arrest form, Your Honor, does not indicate the age of the victim. It only describes the person as an elderly Black male.
State.
Okay, yes, Your Honor. So the second page of the arrest form, which I defense counsel may not have, we usually don't provide it with the victim's information, does allege the age of the victim, which we can provide to Your Honor, and given the instance, we can send defense counsel an email with the date of birth.
Your Honor, my page 2 does not have the date of birth.
Page 3, wait, 1 second.
Page 3, my page 3 does not have the date of birth. My page.
It's so counsel, this is the last page, which usually defense does not receive, but it is a part of the arrest form, and it can be produced in discovery given the circumstances, and we can share it with I'll provide it to you.
I'm gonna take a look at it.
So, Your Honor, that being part of discovery, of course, is provided once a charging document is filed. Here, for purposes of the bond hearing, the 4 corners of the 3 pages of the arrest affidavit do not include the age of the alleged victim. It only says elder.
So you're asking for a probable cause hearing?
And if, yes, and honors, is Your Honor taking note of a back page of an arrest affidavit?
I'm not taking note of anything until we discuss it. They have handed me a page. It is not clear to me that it is part of the arrest affidavit, so I would not be comfortable making a finding based on it. I can't tell if it's part of the A form or if it's separate. It doesn't, it's page 1, and the A form has page 3 of 3. So if what you're asking for is a probable cause hearing, I can do that.
Yes, Your Honor.
All right. State you'll bring a witness tomorrow. I'm setting this for probable cause hearing tomorrow morning.
So, Judge, at PCH?
Yep.
Yes, Your Honor, and just for purposes of the record, Judge, the page that we have provided the court, it does say complaint arrest affidavit on the side, but it does only say SAO copy. We can have a witness here tomorrow, Judge, for the PC argument.
Kalen Gross. So sir, we'll see you back here tomorrow. The officer's gonna have to come in and testify, otherwise we'll make a different decision, okay? We'll see you tomorrow morning.
Judge, Mr. DeBose refused, reset for tomorrow.
How many times is he refused?
Just a second.
All right.
Your Honor,
Martin Morales.
was here. Your Honor, we had Mr. DeBose here. Kalen DeBose, he's here.
Are you Mr. Morales?
No, Your Honor, this is Kelvin DeBose. You're Kalen, sorry, Kalen DeBose.
So he did not refuse?
Oh, he's here, Judge.
All right. Good morning, Mr. DeBose. Good afternoon, Mr. DeBose. Defense, have you reviewed the applications? Do you have an argument as to probable cause?
Yes, Your Honor, I have reviewed the arrest affidavit. It indicates the lease account, false name after arrest. There's nothing indicating in the arrest, Your Honor, that Mr. DeBose gave a false name after arrest. Says that he said other things, but he did not give a false name after arrest.
State.
And Your Honor,
Correct.
state, sorry.
Counsel, I was just clarifying that the probable cause argument was just as to the false name. Is that correct? Counsel?
Yes, that's all the argument. You have a response.
Thank you, Judge. Your Honor, we would be asking to reset for a PC hearing for tomorrow.
No. Okay. There's no probable cause for the false name at this stage. I'm not setting this for probable cause hearing. Let me hear the parties. I'll find probable causes to count one. Let me hear argument as to bond.
Your Honor, so given Mr. DeBose's current lack of housing, if Your Honor, at this time we'll consider release of the alternative program.
I'm gonna hear from the state first, then I'll give you the chance to respond and then I'll make a ruling, okay?
Thank you. And Judge, just as to the false name, if I can make one comment, or you've already, Judge?
Yes, I have.
Understood. As to the bond, we would ask for elevated bond because the defendant has two 2025 convictions, one for trespass and one for theft. He also has a domestic violence conviction from 2015 and other charges from 2025, such as obstruction with an investigation.
Ms. Gray, sorry about that, but it's easier for me to say one after the other. That way I can hear everything. So your turn.
Your Honor, why do you know that the 2025 conviction, it initially started off as a felony, but it looks like it was bound down to county. So they were both two misdemeanor. So again, if the court denies my request for the alternative program, that Your Honor, I'll give Mr. DeBose a reduced amount of bond from the standard bond.
All right. Standard bonds appropriated here. I'm ordering $2,500 on count one, released on count two because I found no probable cause. I'm also going to order that you stay away from the Burlington store on 6th Street. Do you understand?
You just have
Judge, count two is released outright.
Yes. I'm sorry, sir. I couldn't hear you.
I'm sorry. The judge is asking, do you understand that she just gave you an order that you have to stay away from that Burlington?
I understand the Burlington, but I'm saying the 2,500. I was thinking of a program I was released to because I am homeless and I don't have nowhere to go. So even if I do have a bond and the bond is paid, I still don't have nowhere to go. So you as a judge, I'm asking, can you help me to get released to a program so I can have somewhere to stay into the next court date if we are set up the next court date instead of being in jail, losing weight like I've been doing this whole year?
Sir, I'm not in a position to help you today. I understand what you're requesting. Ms. Gray is going to get you in touch with the right attorney, so she's going to try to figure that out.
And I do this every game that y'all play. I'm gonna be in here for 5 weeks, call my sister, not get a bond. This on YouTube recorded. Everybody see it. The same thing that I've been doing. So it's not an argument. It's just what I've been doing. God bless you.
Martin Morales.
Mr. Morales, the interpreter? No.
All right, with the assistance of the interpreter, good morning, good afternoon, sir.
He just said no, Your Honor.
Need an interpreter.
Defense, any arguments to probable cause?
Yes, Your Honor, I do have an argument as to count two. controlled substance possession of one unknown pink pill.
Right?
But has it been stated, Judge, what the argument is?
Yes, she doesn't understand how somebody can arrest be arrested for an unknown pink pill.
Okay, understood, Judge. I believe that that was not the only reason that the defendant was arrested, Judge.
Right, but that's count 2.
For count 2, Your Honor, it's the contents possession. The A form also alleges that the defendant had powder cocaine inside of the vehicle, as well as marijuana and
Right, counsel, I'm sorry, I don't mean to interrupt
Yes,
you, but I want to help you expedite this.
Yes.
I think you heard. She's not making an argument as to count 1, the cocaine possession, or the firearm possession, or the cannabis possession. She's
Yes.
just arguing that there's no probable cause for count 2, which is possession of an unknown pink pill.
Yes, Your Honor. Then we would be stipulating that.
I'm gonna find no probable cause on count 2, but I will find probable cause on the remaining counts. Let me hear from state as to bond.
Apologize, I have to correct the record. The 150 grams of marijuana would be count as a controlled substance.
Again, that's gonna be count 4, which is an F3 possession of cannabis more than 20 grams.
Understood, but it was not printing for us. For the bond, Your Honor, we would be asking for an elevated bond, given that the defendant has 7 local convictions. He also has other firearm convictions, such as a firearm discharge from 2004, and the possession of a firearm by a felon from 2012. That is also a conviction, has also lots of out-of-county priors.
Defense.
Your Honor, defense acts for pre-trial release with alternative bond, and Your Honor, with respect to Mr. Morales' prior record, and I'm of course just referring to what showed the 98 Cameron Steve's priors. His last conviction was in 2011. That was 14 years ago, and another one is shown to be 2007, which is 18. So we'll actually, Your Honor, will consider reducing Mr. Morales' bond to the standard or form of release.
All right, respectfully, after having reviewed the priors and the allegations in the affidavit, I'm ruling count 1, bond of 2,500, release on count 2 because there's no probable cause, count 3, 5,000, and count 4, 2,500.
And I'm sorry, did you say count 4 is
2,500.
okay?
Patrick Watson. All right, you're Mr. Watson?
Yes, ma'am.
Good, thank you, sir. Do you speak English? Sounds like you do.
Yes, ma'am.
All right. Ms. Gray, any objections to probable cause?
I should know. I have agreement as to no probable cause with all 3 of the alleged offenses. Your Honor, my reading of the arrest affidavit is that there was a warrant that was executed at a residence. That residence, Your Honor, inside that residence there were some items, but there were also some items found inside of a BMW that were parked in the driveway of the residence with a co-defendant's ID inside that BMW.
I'm sorry, I'm gonna have to convey your argument to the state because the state can't hear you, but I can. What counsel is arguing is that the items that were found inside a vehicle with a driver's license that belonged to someone else. Does that summarize your argument, Ms. Gray?
Yes, Your Honor. There was a list of things that were found inside of the black BMW. And if Your Honor looks through those items, if the state looks through those items, there is nothing indicated in those items that one of the things that was found is a bump fire stop. And count 3 alleges import for sale and distribute a bump fire stop. If Your Honor then also looked at that list of things found inside the black BMW, it speaks of an AK-47, some live weapons, and a 9mm. Nothing is indicated there of a shotgun being found inside the black BMW, in which the ID was, the identification was found inside of the car that did not belong to Mr. Patrick Watson. If Your Honor then looks at offense number 1, which is possession of a firearm and ammunition by a convicted felon, Mr. Watson was stopped by the search team, Your Honor, inside of a black Honda. There's nothing found inside of Mr. Watson's black Honda that would either be actual or constructive possession of a firearm.
Okay. We're still only on the first aid form here. That's 26700.
Okay.
The question comes down to what ties Mr. Watson to the various items.
Yes, Judge. Well, Mr. Watson was in the vehicle, Judge. I believe that he was the driver of the vehicle. He entered the black Honda, and that's when the traffic stop was conducted, Your Honor.
Do we have any information as to whether or not he was the driver or a passenger in that vehicle?
He did enter the vehicle, Judge, so because the A form alleges that he entered, he was occupying the vehicle, and that would tie him, Judge, to the.
And Your Honor, respectfully, the vehicle that Mr. Watson is stopped in is a black Honda.
And nothing is recovered from that vehicle.
The car was searched that was in the driveway is a BMW.
Your Honor, there was also a search of the residence which discovered the Glock, multiple Glocks that were there, Your Honor, so that would tie him to the guns.
Does anything indicate who lives at that residence? Or what rooms they were found in?
He does, Your Honor. The address that's stated on the arrest form is the same one that's listed as his residence.
Okay. Who else lives there? What rooms were the items found? We don't have any of that information.
Your Honor. Understood.
You're gonna have to turn on the microphones.
The backpack that it was retrieved from, only
what was retrieved?
that the 40 live rounds were retrieved from belongs to Mr. Nelson. So as to that item, we stipulate that there is no evidence in the arrest form or anything alleged in the arrest form that would tie him to the live rounds. But as to everything else, the arrest form does not actually allege which room it was found or how they're tying it to Mr. Watson. So we would stipulate to that argument.
So you're agreeing that there's no probable cause as to any of the counts in case 26700?
Not as to any of the counts, just as to what was found inside of the residence, Your Honor. What was found inside of the car, we are not stipulating to because Mr. Watson did step into the vehicle after he exited the residence. And we can prove it by constructive cause.
No, that's insufficient to show probable cause at this stage. You have no idea where he was in the car, what he did not know what was in the car. You have no evidence as to whether it's his reach or that he has custody or control of the items.
Your Honor, we would argue that we could prove it through constructive control, given that there were multiple items found in the vehicle, including backpacks, the guns, the rounds, the empty magazines, and that he was a member in that car.
There's nothing in these A forms that gives you that. So have a probable cause hearing or I can.
Your Honor, we would be asking to have a probable cause hearing tomorrow.
I'm gonna set this for probable cause hearing tomorrow. There's a lot going on here. You're gonna need, because looking at both of these affidavits, I have concerns. So we'll need more information. So this will be reset, both cases reset for probable cause hearing.
Thank you.
So, Your Honor, will the court consider setting any bond on any of the accounts so that Mr. Watson does not have to stay in custody?
Sure, but you asked me to not issue a bond because you're saying there's no probable cause, so that's the choice.
Your
you
Honor,
have.
I do. Mr. Watson is asking if the court will set any form of bond. I do, and I do stand by my argument now that there's no piecing for any of the 3 or 4 offenses for which Mr. Watson was arrested.
I don't know how to set a bond if you're arguing there's no probable cause. So either I can set a bond and you waive that argument, or you can come back tomorrow. I understand it's a frustrating choice, I really do, but I don't know how this court can say.
Right. So, Your Honor, the fact of the matter is that even if this, and I'm not sure if the state is requesting a probable cause hearing, but even if the detectives come in tomorrow, or the officers come in tomorrow and say that these items were found, there's nothing indicating, unless they're going to perjure themselves, but there's nothing indicating that any of those firearms were found in the black Honda in which Mr. Watson was stopped.
Right, but there's also another vehicle, there's a backpack, and there's a home. So there are more items than what you're discussing. I agree that the allegations in the A form don't put anything in that car, but it does put things in other places, including the address where your client lives, according to the
Just respectfully, if Your Honor looks at the arrest affidavit, there's nothing that indicates that the arrest affidavit that was obtained by the officers for Mr. Watson was on any type of formal ID that they obtained from Mr. Watson.
I agree with you that the probable cause is likely lacking, but the state is entitled to have a probable cause hearing. I cannot deprive them of that right, just like I can't deprive you of that right. So
I understand.
This will be set for probable cause hearing tomorrow.
So, Your Honor, you can't get no way. I got all the stuff going on.
Sir, you're gonna have to talk to your lawyer. I am only limited in what I can do, and your lawyer has done a great job arguing. The alternative is I can set a bond in this case and you can waive that argument. I can't go back and forth multiple times. So Ms. Gray, if you want a minute to speak to your client and decide on a course of action, I can do
Mr. Watson, the judge can set a bond for you. That means you will not have a probable cause hearing tomorrow.
And if they do not, then that's bad.
It depends on how you look at it. I mean, so Your Honor, Mr. Watson is asking for the court to set a bond on the arrest affidavit that has been filed.
How they finish?
Yeah.
I'm going to.
So Your Honor, we're asking the court to.
All right, based on the request of the defense to set a bond. All right, I've had the opportunity to review everything. Your client has an address. Ms. Gray, your client has a permanent address in Miami?
I couldn't hear you.
Does your client have a permanent address in Miami?
He says that he has a permanent address in Deerfield Beach.
But my sister, I don't know my address by heart.
Okay. Do you live in Juno Beach?
Yeah, I live in Deerfield Beach.
Deerfield Beach. All right. I'll set a bond of $3,000 on count 1. I'm sorry, I'm on 26699.
So we're addressing
26699, and I may have already done the no valid driver's license this morning.
269. He has one count.
Forget that. So it's just 3,000 on the count 1. As to 26700, I'll issue a bond of 3,000 on count 1, 3,000 on count 2. And 1,000 on count 3. That should bring the total bond to 10,000. 15. And
Hello, interpreter, can you hear me?
Yes, interpreter present.
We will need a Creole interpreter at some point on the calendar. If you could get
I
a
could
report-
call one of the
Try
two
calling and make
ladies
it
right
up.
now.
All right, we have Nicholas Gunther.
Miss Gray.
Come on. Yeah.
Hi, Mr. Gunther, you need an interpreter.
No, sir.
All right, Mr. Gunther, you speak English?
Yes, ma'am.
Defense, any argument as to probable cause?
I do not hear this.
Go ahead.
I said I do not hear you.
Okay. I'm going to find probable cause based on my review of the affidavit. State, do you wish to be heard as to bond?
You're asking for standard bond on each count.
There's no files?
He has no
Your Honor, that's also the next requires Mr. Gunther.
Oh, sweet. Can she talk?
Your Honor, I was told that Mr. Gunther's wife is on Zoom. I don't know if she could address the court.
All right. What is your wife's name?
Christine.
All right. I'm not sure. Do you want her to address the court?
Yeah, I think I would.
I was kind of talking to your lawyer there, Mr. Gunther. Let her make the decision. She's trained to do that, okay?
Yes, yes, Your Honor.
Miss Gray, I have allowed Miss Gunther to speak. Do you want to ask her anything or have her tell me anything?
Your Honor, I don't know if the office of the state attorney has already spoken to Ms. Gunther. I will, assume she's here for a reason, hopefully to get good information about Mr. Gunther. Yeah.
All right. Is Miss Gunther the alleged victim of a burglary? Are they in white?
I believe judge has to take usually we have a right in task to be heard.
And sort of do they live in the same home?
Your Honor, they have been living separately for 3 months, and that's why I asked for the stay away order.
Do you want Miss Gunther to? Miss Gunther, good morning, good afternoon. This is Judge Moore. Do you have any reason you wish to address this case? Miss Gunther, you're muted. You would have to unmute. Ms. Gunther, I'm giving you the opportunity to speak. If you wish to address this case, I've asked you to unmute. All right, it appears that Ms. Gunther is electing not to address this case.
Hello?
There we go.
Oh.
Ms. Gunther, good afternoon.
Hi.
Hi, did you want to address this case? You are not required to do so, and anything you say may be used by either party here today. But if you wish to address this case, I will hear from you, ma'am, regarding release.
Yeah, I would love to be able to pick him up as soon as possible because there seems to be a much more intense, the charge does not fit the crime. And it was, burglary. He was just entering my home. I was asleep, long story short, that's really extreme. And I don't think it's punishment for the crime. I mean, the crime is not burglary.
I'm going to place you under oath, ma'am, so that we can ask you a few questions.
Good afternoon, ma'am. Raise your right hand. Do you swear from the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? If so, say I do.
Yes.
All right, is the defendant who's standing in front of you your husband or significant other?
Correct.
And how long have you two been in a relationship?
10 years.
Do you feel that you are in danger if he is released?
No, I do not.
Do you have any children in common?
We do.
Do you wish to have a stay away order entered so that he cannot come back and see you or your home?
No, you know what? No, I need to. I don't think we should see each other right now, but no, I don't want to. No.
You don't want an order that gives you the protection of requiring to stay away?
No.
All right.
All right.
Yes. Ms. Gray, any further?
With that said, Ms. Gunther, I will ask if the court will consider a release to pretrial services. Mr. Gunn, in fact, has an address here in Miami-Dade County. I do not show any Miami-Dade County priors for him. I will ask if the court will consider a release to pretrial services and an alternative.
He doesn't qualify for pretrial. I don't think. All right. I'm going to find probable cause. I'm going to issue a bond in the amount of $1,500, which is a significantly reduced bond in light of the circumstances here.
Thank you.
For the time being, I am going to order Mr. Gunther that you have no contact with the alleged victim in this case or the children that you have in common. You have the right to raise that with the judge, and Ms. Gunther, you have the right to raise that with the judge. But the court has observed your testimony and your hesitation here and your desire for there to at least be a cooling off period. And in light of that, despite your request that I not do a stay away order, I'm going to do so. Again, either party has the right to readdress this. Sir, when you postpone, if you postpone, I'm going to give you the following instructions. You may not engage in any criminal activity. You may not use or possess any illegal drugs. You may not use, possess, purchase, or carry a firearm, gun, weapon, or other ammunition. Do you understand?
Yes.
Yes.
You are to have no contact with the alleged victim in this case, who is present and whose initials are CG. That means you can't email her, you can't text her, you can't call her, no messages over social media, and no messages through third parties. Do you understand?
Yes, sir.
All right. Do you have anything from that home that you need to pick up?
We don't live together.
Okay.
But here's, may I just say something? He is leaving town. This is the reason I'm here to help, because he's leaving town in a day for a very important job interview. So he'll be gone.
No, he'll need to come back for court. Otherwise, a warrant will be issued for his
I mean,
arrest.
it's like a day. It's 2 days just to meet the team.
So today, I am letting you a bond of $1,500, which is significantly reduced. I'm ordering a stay away order. I read you all of those instructions. Did you understand better?
I do, and thank you.
Yeah, my understanding is there's 2 counts.
Yes.
It'll be $750 on each.
Your Honor, Christine, I know I'm not allowed to communicate with her.
You won't communicate with her at all.
I have a question about that. Who do we communicate through? Because we do have our son, and there's a lot of stuff going on, like Christmas and babysitters while he's out of town and work. There's a lot that we need to have a middleman for. We have a lawyer. We have
and you're gonna have to take that cooling off period. But for right now, next little bit of time, you all are not gonna have any contact.
Okay.
Your Honor, this is what's great. I have a question for the court. Will Your Honor consider no harmful contact with the stay away order?
I am concerned about the safety of all the parties involved. I've observed witness. You can re-raise that in front of a different judge in a few days, but for today, we're gonna have that cooling off period to protect the safety of all parties.
Okay, because Mr. Gunther explained to me that Ms. Gunther has access to Mr. Gunther's funds in order for the bond to be posted. And it's just that in order for him to communicate with her,
if Ms. Gunther wants to call his mother to post a bond, she can do that. She can have that communication, but he cannot have communication with any third party or direct.
I'm sorry, I didn't hear what she said. Just let me know what to do.
If you want to call his mom and ask her to help him post bond, if you want to post his bond, the court cannot do that. But I am going to say, no, sir, that kind of contact is exactly what I just said you can't do. I know you aren't trying to be disrespectful, and that's all right, but I need you to acknowledge that I have said, until a court readdresses this, you are not going to have communication with Ms. Gunther. Do you understand me?
Yes, sir.
All right. I appreciate you respecting that order. Ms. Gunther, I am not precluding you from contacting his mom to post bond should you choose to do that. But that is not your obligation or responsibility. What I have ordered is that you all will not have any contact for the next little bit of time until the judge readdresses.
Okay. How does she go about paying? I'll call her immediately.
I can't get involved in that. You'll find instructions from the Department of Corrections.
The Department of Corrections?
Yes, ma'am.
Thank you.
All right. Thank you. Elia Noah.
Yes.
Thank you. Thank you.
Thank you, sir. Elia Noah.
Yes, good afternoon.
Good afternoon, sir. You speak English?
Yes, ma'am.
I'm sorry?
Yes, ma'am. I speak.
All right, thank you. Ms. Gray, any objection to finding a probable cause?
I do have an objection specifically with respect to the armed possession of the sheep, which is the way as a second.
What is the basis of your argument?
The arrest affidavit, Your Honor, first of all, alleges that a clear black and colored glass container that had the label of styrofoams on it, so let decide with hashish, but the officer also recognizes that it's a THC extract of marijuana.
I'm sorry. Maybe I didn't understand your argument.
That my argument, Your Honor, is the degree of the felony alleging armed possession of hashish, understanding that hashish is the derivative of THC.
Right?
So, at this point, Your Honor, in terms of finding probable cause, without having any field testing or anything done to, in fact, determine that that material, that item, substance, was hashish versus THC. Because THC is not necessarily listed under the same control substance schedule as hashish.
All right, but armed possession of cannabis, if it wasn't hashish, would be the same.
Would not be something.
Armed possession of cannabis is not a felony?
It would not be secondary. I can double check and make sure I understand the control. Substance that is correct, right? And check again.
That is not my understanding, ma'am. But I could be wrong. I believe that there's probable cause here, so I'm gonna make a finding of probable cause. The state, do you want to respond to the argument?
I believe Your Honor has found probable cause. There's no response at this time.
Your Honor, the court will set bond, Mr. Noel. My date requires for you to indicate that this is that he has no prior. I would or conviction. I don't know if it has something different. The affidavit shows that he is employed.
All right, state.
For standard bond.
I'll do pretrial with an alternate bond of 5,000. All right, thank you, sir. Have a good afternoon. Charles Brogdon.
Your Honor, on his application, you gave him a bond of 150.
Okay, thank you. No.
Are you Mr. Brogdon?
Good afternoon, sir. You speak English. I remember you from this morning.
How you doing?
Defense, any argument as to probable cause?
No, it's probable.
All right, the court finds probable cause. State is to bond.
We are asking for standard bond, Judge.
Defense.
Your Honor, what the court did this morning on the traffic offense, I will ask Your Honor, consider a pre-trial release of Mr. Brogdon. I don't have anything prior to Mr. Brogdon. He was here in the state of Florida, and he does appear to have a permanent address listed on the arrest affidavit.
Standard bond is 2,500. I think that's appropriate here. 2,500. Roberto Lopez.
Lopez.
gave me.
Mr. Lopez is out on felony bond, Judge F 25-18679.
You can get a
Thank
bond.
you.
They'll pay $250. You let him.
Oh,
What's your name?
Lopez.
All right, Mr. Lopez, do you speak English? You'd prefer the interpreter?
Yes.
All right, with the assistance of the interpreter, good afternoon, sir.
Buenas tardes, señor López.
Ms. Gray, any objection to probable cause?
No.
Le están preguntando a su abogado si ya tiene argumento en contra del motivo fundado, está indicando que no.
I'll find probable cause as to bond.
Su señoría ha determinado motivo fundado, está pidiendo sugerencia de fianza.
We're asking for standard bond, Judge.
Defense?
Fianza de rigor, dice la fiscalía.
My son is bonded $2,500.
Yes, but he's also out on bond on F25-18679.
Understood.
So he'll be
Su
held
abogado
on
está
that
preguntando si la fianza es 2.500. Su señoría le dijo que sí, pero usted también está fuera. ¿Es it a bond or probation? Bond, right?
case. Yeah,
Usted está fuera bajo fianza por un delito mayor de este año, así que va a ser retenido.
I'm issuing bond of $2,500 in this case. He'll be held on F25-18679 in a few days.
Que usted en este caso tiene fianza de 2.500, pero en el caso previo de delito mayor, donde también tiene fianza, lo van a retener hasta el lunes para ver su juez de división.
Anderson, Zacharias, Lopez.
Okay. So you can step out. No problem. Okay. Your Honor, this Zachary Lopez is here, the interpreter, sir. Yes, you will need him.
All right, with the assistance of the interpreter, good afternoon, sir.
This for Spanish or Creole, Your Honor?
Spanish.
Okay, thank you.
Defense, do you have any arguments to probable cause?
I do, Your Honor. Argument is no probable cause. There's no allegations of any deadly weapon, no unlawful touching in the arrest affidavit.
Su señoría le está preguntando al abogado de oficio si encuentra que hay motivo fundado, argumentos en contra del motivo fundado, y está indicando que sí, no hay alegato de armas, ni tampoco hay ningún alegato de tocar.
Your Honor, the arrest form does not allege the type of weapon, however, it does allege the police case number. It seems that the defendant was picked up after the incident actually took place. We would be asking for probable cause here, Your Honor.
Bueno, en realidad no se encuentra que hubo motivo fundado durante el delito, porque al acusado lo recogen después del delito. Así que la fiscal adjunta está pidiendo que haya una vista para demostrar motivo fundado.
So, Your Honor, what I understand is they can ask for a probable cause hearing, but essentially they're asking for a probable cause hearing on an A form that hasn't been filed. For purposes of this hearing today, that there's no probable cause in this case, 2526685 for aggravated battery.
State, do you have any information on what the alleged weapon is?
Not at this time, Judge. For purposes of the first hearing, hearings, we will stipulate to no PC given the allegations are not on.
There's PC for misdemeanor battery.
Le están preguntando a la fiscalía si tienen más información sobre el motivo fundado con el arma.
I'm issuing a stay away order.
Una fianza de rigor $1,000, orden de alejamiento de
Sir, the alleged victim. I'm going to order that you stay away from the alleged victim and not have any communication or contact with that person.
Señor, le estamos ordenando una orden de alejamiento de la supuesta víctima. No puede tener ningún tipo de contacto o comunicación con la supuesta víctima.
Do you understand my instructions?
¿Usted está entendiendo las instrucciones de su señoría? I can't hear him.
$1,000, 1,000.
Yes, with the stay away order. Do you understand my instructions, sir? That you must
$1,000
stay-
de fianza con orden de alejamiento. ¿Está usted entendiendo la orden de alejamiento de su señoría, señor?
Sí.
Yes.
Thank you very much.
Muchísimas
Vincent
gracias.
Flores. I'm sorry? Oh, Says yes. Mayor and Richard. With the assistance of the Creole interpreter. Good morning, Ms. Wilson.
Good morning, ma'am.
Good afternoon, Judge.
Good afternoon. Interpreter, please raise your right hand. Do you swear that you will well and faithfully interpret from English to Creole, Creole to English, the questions asked and answers given to the best of your ability, and that you have such ability? So say I do.
I do, Carol Wilson, court certified interpreter.
All right. Defense and argument is to probable cause.
Avocat la défense, est-ce qu'on a argument pour bon genre raison pour arrestation?
Your Honor, are you, Madam Interpreter, can you ask him, is his name Vincent Flores?
I'm sorry,
ca-
what?
This is. Yeah. I'm sorry.
Ms. Gray, I can't hear you at all. I'm sorry. You're gonna have to repeat that. This is Mayor and Richard. It's the third from the last case.
I'm sorry.
That's okay. Should have warned you.
Person. Yes. Argument is probable cause for the robbery. There's no allegation in the arrest affidavit that any property was taken. The arrest affidavit, Your Honor, just alleges that a wig was forcibly removed from the individual's head, but it indicates that the wig was taken, and if you want to say the temporary deprivation, but when the wig was removed on the floor, I can't really talk about or call a form, so I'd say my argument is no.
Doesn't it specifically say he removed it, she attempted to retrieve it, and so he pulled a firearm?
Your Honor, I'm sorry, but I can't hear any what Ms. Gray is saying. I don't know what she said.
Okay, Ms. Gray made the argument that there is not evidence of a robbery.
Avocat la défense nan di ke l pa wè ke gen preuve ko te eseye vole.
The court is asking the state for a response.
Avocat la tribunal la mande avocat l'État yo pou yo ba nou repons sou sa.
State,
Thank
do you
you,
have evidence of a robbery within the four corners of the A-form?
Est-ce que wè te gen se preuve pou ke li te ke yo akuse l de vole nan form arrestasyon?
Yes, Your Honor, for the PC argument, the state's response is that it is a attempt temporarily or permanently deprive someone, Judge. And in this case, he did grab the wig and begin to try to walk away with it. He brandished the firearm during this. This was because she had failed to engage in sexual interactions with him. So we do believe there is probable cause for the robbery, Judge.
I'm sorry, Judge, I still didn't understand.
The attorney made the argument that the wig was taken and not returned, which is temporary deprivation.
Avocat l'État yo di kon sa ke se vre ke l te pran bagay la, ke l pati se vole li, men ke l te pran li.
That the court has reviewed the arrest affidavit and finds that there is probable cause.
E tribunal la wè ke nan form arrestasyon, gen bon jan rezon pou sa?
The state has now handed me a motion for pretrial detention.
Judge, just
Kounye,
for the record,
avocat l'État bay tribunal la un motion pou yo meto nan program ki rele pre-trial diversion.
Your Honor, just for the record, it is a first degree felony, punishable by life. It is robbery. Pretrial detention, or denied, alternative, GPS.
Ms. Gray.
Your Honor, just if the Creole interpreter can say it was a motion for pretrial detention, not diversion.
Monsieur, excusez-moi, program nan c'était pas pre-trial diversion, c'est pre-trial detention. Ça veut
Yes.
dire que ta ken bon en prison avant jugement. Thank you, Ms. Gray.
And I'm sorry, we can't really hear the state attorney on the side. I heard her say that she filed a motion for pretrial detention.
Yes,
And then
and she noted that this is a life and a violent offense because of the firearm.
Okay.
Let's let Ms.
Et à cause de zam nan que Ms. Gray di an dire, elle t'étendait avocat l'État a offri le pre-trial detention. Et juge la dit oui à cause de zam nan.
Your response.
I will actually hear that the matter be scheduled for a hearing.
I'm sorry?
I'll ask that the matter be scheduled for a hearing, Your Honor, if the state has in fact filed a motion today.
M'ta remè que yo mette ça de pour l'audience parce que jodi a avocat l'État yo dépose une motion.
Alright. I'm finding the defendant has been charged with a dangerous crime,
Moi, trouvé que yo accusé à d'un crime qui dangereux,
that the offense is light felony or felony in the first degree,
I'm sorry, Judge, could you repeat that, please?
that it is a felony of the first degree or light felony,
Et que son crime, un gros crime premier degré,
and that there is probable cause the defendant committed the offense.
et que gen bon jan raison pour ça.
I'm going to order the final hearing be held in a trial court within 5 days of today's date.
M'pral demander que yo mette le devant un juge pour audience en date jugement 5 jours après à commencer à compter à partir de jeudi.
Your Honor, is it no bond? Hold on motion?
Be held pending that order. He'll be held pending that hearing. So yeah, no bond until.
No bond. Thank you.
Et le
And
département correction m'a dit juge est-ce que gen caution? Le juge l'a dit non, comme il pral devant l'autre juge, pas gen caution.
Vincent Flores. Mr. Flores, English?
Finally,
Alright, will you
Spanish.
order to assist us? Good afternoon.
Buenas tardes.
Defense, any objection to probable cause?
Yes,
Preguntando a su abogado de oficio si encuentra que hay argumentos en contra del motivo fundado.
the arrest affidavit is specifically unclear as to the specific days that Mr. Flores did not report. Only indicates that on the 2nd of 2025, that he had been released from a Broward jail.
Ella sí, ella dice que no está claro en la atestación cuáles fueron los días que usted faltó, ni dice fechas específicas, sencillamente fue en junio de 2025, creo.
And then it indicates that, in fact, he did register. Let me get the exact date.
Y luego indica que usted no se matriculó.
It says that he's required to share within the county in which he resides every 30 days for check-in.
Y dice que inclusive usted tiene que indicar cada 30 días a dónde es que usted vive.
And then it says he did in fact respond to the Broward registration office and register as a registered transit address, but unclear from the arrest affidavit, it does not indicate date Mr. Flores responded to Broward office to check in, and therefore we can get an accurate count of 30 days.
Well, it's not.
Dice que en el condado de Broward estuvo usted y que en realidad ellos no pueden contar los 30 días de manera veraz.
The way I read the form, he was told he had to report within 48 hours and failed to do so.
A él le indicaron que tenía 48 horas para hacerlo.
And it showed that he did report to the Broward office and gave them a Miami-Dade County address. What date was that in fact Mr. Flores responded to the Broward office? We do not know.
I don't know if it's that I'm not hearing you or I'm just not understanding your argument, but the way I understand the A form, it says he responded as to Brown, registered a transient address, told he has 48 hours to report, and did not report within 48 hours.
Está indicando que usted había indicado que era transeúnte, que estaba viviendo en el condado de Broward y que tenía 48 horas hábiles para reportarse.
The issue, John, is what date did he report to the Broward Secret Predator Registration Office to register his Miami-Dade County address?
November 2nd.
No, Your
El,
Honor.
November 2nd. El asunto es cuál fue la fecha que él reportó en Broward.
Respectfully, Mr. I'm satisfied that there's probable cause in this A form, so I'm going to find probable cause over your objection. I think that if you're correct and a specific date is missing, that's not necessarily required here. It's that he did not comply comply with the rules, the date can be discovered.
Con todo respeto, ella no está de acuerdo con su abogado porque lo que la regla dice es que él se tenga que presentar.
Let me hear from the parties regarding bond.
Con respecto a fianzas, dígame qué.
Yes, Your Honor, we're asking for an elevated bond. The defendant was just released from Broward County on a different case on November 2025. The defendant also
November
has,
what?
I was slowed down,
No, just November what?
November 2025, the defendant was released from Broward custody for a different charge.
Está indicando que apenas en noviembre de este año usted lo dejaron salir del condado de Broward por otra acusación.
The defendant also served 20 years in jail for sex offense against a child
Inclusive
under
usted
12 years.
cumplió un periodo de 20 años en prisión estatal por ofensores sexuales contra un niño o niña.
Apologies, that was over 12 years. And
Más de 12 años.
Additionally, Judge, he was also charged with lewd and lascivious battery and multiple counts. Given that this specific charge has to do with its sexual in nature and him reporting, we would ask for an elevated bond.
Defense?
And he was recording, you say?
Reporting.
Reporting, ok. Inclusive esta acusación es de conducta lasciva y lujuriosa y agresión corporal a un menor o a menor, agresión corporal a un menor, sí, y que hay múltiples acusaciones de índole sexuales. Y usted se tenía que reportar.
Your Honor, courts not knowing what the offense was in Broward for which Mr. Flores was in custody or what that final disposition was, I will ask if Your Honor will consider at this point a release the tap. I will not ask for withdraw because it's reading my computer because it's home. So that's for release the alternative program.
Right. He does not qualify for pretrial services, and I wouldn't order that. The standard bond is appropriate here, $2,500. So I'm finding probable cause. I'm ordering a bond of $2,500.
Su señoría ha determinado que su abogado pidió que le habilitaran el programa TAP con las siglas TAP. Su señoría determinó que usted no califica para el programa TAP y le está imponiendo fianza de $2,500 y ha determinado que hay motivo fundado ante las acusaciones.
Alfredo Morales?
Mr. Morales is out on felony bond, F25-002-380.
Thank you.
Morales, the interpreter.
No.
All right, you speak English, sir?
Yes.
All right, Ms. Gray, do you have any objection to finding a probable cause?
No objection.
All right, court will find cause stated in the bond.
I believe corrections just stated he has a felony hold, so we would ask for a hold in that case. And as to this case, we would ask for an elevated bond. The defendant has multiple pages more that we can count of prior convictions and arrests out of county. And in county, he has 14 prior convictions. He also has a DUI from 2001 and he has violated probation.
Defense?
Your Honor, with respect to Mr. Morales' prior conviction, Your Honor, the latest one I see is from 2021, and that was for a deductible loss conviction. That's in more recently 20. So, and I do understand felony hold, but I wrote it for keep the standard bond on the case for your Honor.
Standard bond of $2,500 is appropriate, holding case 25-2380. So you'll go see Judge G.
Yeah.
Andrew Grant? Defense, any arguments to probable, Mr. Grant, do you speak English?
Yes.
All right. Defense, any argument as to probable cause?
Yes, Your Honor, this specifically as to count 2, display of firearm during the commission of a felony.
Go ahead.
Nothing in the rest stated that Grant displayed on the commission of a felony. My arrest affidavit, Your Honor, is that this firearm was left inside of the statue, and it was display.
State,
Your Honor, the defendant was the, one of the occupants of the vehicle that contained cannabis, about 120 grams. This is a felony, Your Honor. He did have a firearm while he was in the vehicle with cannabis. All occupants, were in the vehicle. The cannabis was in plain view based on constructive knowledge. We can provide to the court that he was aware of the cannabis being in the vehicle and therefore him having a firearm is sufficient for probable cause.
Ms. Gray, is there something in the case law that you want me to be aware of with regards to what constitutes using a firearm in commission of a felony?
Yes, Your Honor, the use that is playing of this particular. It's a the arrest affidavit that this firearm was found inside of a black cemetery.
All right, but it wasn't hidden away.
Was it
in between his legs at the time of the. He's driving around with it in between his legs. I mean, it's not under the seat. It's not packed away in a glove compartment. I'm gonna find probable cause on this one. State to Mr. Curtis.
We ask for stand upon.
Defense?
Yeah, I'm sorry, they were actually proceeding on.
Yeah, but I don't know. What do you believe the standard bond is?
If it's an F1, Your Honor, it's usually, I believe, 5,000.
Your Honor,
7,000.
There's a felony of the first degree.
They're F2s.
Yes, Judge, so we would be asking for 5,000 is fine, Judge, he has no priors, 5,000 both felonies, and then on the misdemeanor of, we don't have to set up on for the misdemeanor, concealed weapon.
Ms. Gray?
So just stay asking for 5,000 in both counts.
5,000 on count 1, 5,000 on count 2, and you said 500 on count 3?
We can stipulate to $1 in the third.
$1 bond on count 3 is their request.
All right, Your Honor, the court will consolidate the funds for 1 and 2, so the same incident and the same alleged prior. We can't hear the, I will actually, Your Honor, will consolidate counts 1 and count 2 for bond purposes, since it's the same alleged firearm that is alleged for the armed sale and delivery of cannabis.
I'm gonna issue 5,000 on count 1, 2,500 on count 2, $1 bond on count 3. Jaylon?
All right, so bond.
Bond out.
Thank you. Mario? Oh,
Is that
you're Mr. Santal?
Yes, ma'am.
You speak English?
Yes, ma'am.
All right, Ms. Gray, any objections to probable cause finding?
Yes, Your Honor. Argument is no probable cause. There's nothing in the arrest affidavits to indicate actually or constructive possession. The firearm was in the BMW that was parked at a house. The arrest affidavit that's listed, I'm sorry, the address of the arrest affidavit for Mr. St. Paul is listed at a different address from where the search happens.
Dave?
Your Honor, we're already having a PC hearing for one of these co-defendants tomorrow. If Your Honor, would be inclined to set the PC hearing for this as well.
Is that what we did on the last one?
No, Your Honor, Your Honor set a bond.
I think they waived their PC argument at the end. Excuse me, Judge. We would be asking to set for PC hearing for tomorrow, Your Honor.
It's great.
Your Honor, the court will set a bond in the possession of firearm victim felony case or charge or.
I don't have a copy of this defendant's prior to this.
Your Honor,
Are there any? All right, if we're not having a probable cause hearing, I would issue bond in the amount of $5,000.
The state would just like to note that the defendant has been convicted previously for robbery with a firearm.
All right. So PC is waived.
The judge,
Yes, ma'am. Corrections, do you have a question?
I was asking you, was the bond 5,000?
5,000.
Thank you.
Garfield Nelson. This is the same A form. I don't think there's any difference. So Ms. Gray, do you want a PC hearing or do you want a bond?
He have the backpack, Judge. He was the one defendant that is identified in the A form as having the backpack.
Where is that?
So in the bottom of the arrest form, it says that the backpack that was found containing the live rounds contained Mr. Nelson's Florida identification card.
All right, Ms. Gray,
Yes, Your Honor.
do you have any other argument?
Your Honor, I do argue with respect to the possession of weapon ammunition.
The charge is possession of ammunition, search that the extended magazine with the live rounds were found in a small backpack with Mr. Nelson's Florida ID.
Your Honor, it seems like he was on probation previously. The probation ended back in April, but they do include weapon-related charges. He has about 10 other local convictions, some of them felonies, including weapon in possession of a felon.
Right now, we're just determining whether to grant an objection to promise or loss. Ms. Gray?
Yes, Your Honor. The state attorney, with reference to Mr. Nelson's prior, that they're indicating that he was previously on probation.
Yes.
From 2016.
There was also 18 months in 2019. Actually, it probably started a little later than that. But I'm not sure the probation is really the relevant question. Looking at the priors and the prior convictions, I'm gonna find probable cause on this case. Looking at the priors and the allegations here, I'm gonna set a bond of $7,500. All right. I have Arnold Escalona. Mr. Escalona? Are you Mr. Escalona?
I do want to stipulate a couple of things in the report if we can.
No, I cannot. But let me tell you, Mr. Escalona, what you're saying today is being recorded.
No, I understand. I'm just saying that I just want you to understand that on the document, it said that I was supposed to get my phone to look at my phone.
Mr. Escalona, do you understand that everything you say right now is going to be used against you by the prosecutor? You have a really good attorney who's been making great arguments for people all day. Your best bet is to talk to her and let her make arguments on your behalf.
As well, I'd like to speak to her really quick and explain to her what I'm trying to determine paperwork.
I'm having trouble understanding you, but if you're asking for a second to speak with Ms. Gray, I'll allow you a minute, but we're going to move forward quickly. 1 minute, Ms. Gray, can you turn off your microphone?
If I can make probable cause arguments, and maybe that may satisfy Mr. Escalona.
Okay.
Okay. First, let me first, Your Honor, burglary to an occupied structure. It has listed here as a second-degree felony. I can only assume that that particular address, I'm guessing you're saying, is the mailbox area of an apartment. And don't know the door water is a business or an apartment. If it is an apartment, then I do understand why the second degree felony. With respect, Your Honor, to count 3 of the possession of intent to sell or deliver, I think it's supposed to be prescription drugs. That in this form, Your Honor, alleges that there were pills inside of the pill bottle, not associated with the bottle label. It doesn't say that the bottle label did not have Escalone's information on it. It was just there was commingling of pills inside of a pill bottle.
It says a prescription pill bottle not belonging to the defendant.
Yes, so I don't understand why I'm being charged, but I want you to understand that on that thing,
I've had the opportunity to review the affidavit, and I'm satisfied that there's probable cause for all 4 counts. Well, now I've got to.
Well,
yeah.
Where?
I'm gonna type. Okay. I do see the probable cause for the 4 counts of the credit card dealing. That takes us to the 8 or 9. And I do see probable cause for each of the different. All right, I do find probable cause for all 12 counts. They are laid out here, but I can understand and find probable cause on all of them. State, do you wish to convert us to bond?
Yes, Your Honor, the defendant has 13 prior convictions and 8 withholds on adjudications from Collier County. You would be asking for an elevated bond, Judge.
And
those
convictions to the issue of bond.
Hang on one second. I had a question for the state, and then I'll come to you, Ms. Gray.
Collier County Judge, one moment while we can provide that for you.
I'm just looking for a sense of what kind of crime.
Yes, I believe they varied. They varied from criminal trafficking to misdemeanor petty theft, burglary, grand theft. He was on probation for grand theft.
Nothing violent.
Burglary, assault, factory.
When was that?
The year that all were charged.
All right. Defense?
So, Your Honor, I do understand that the court has already made a finding of probable cause, but I would just like to put into the court that with respect to the credit card obtaining goods or values of $300 or more, the arrest affidavit does in fact state that there were credit cards that were used, but it doesn't necessarily indicate any nexus between Mr. Escalona and the using of these particular credit cards. It only talks about how the alleged victims were getting notifications from their various banks that their credit cards were being used.
I have found probable cause, and I'm going to stand by that determination. Do you want to be heard, Mr. Bond?
Your Honor, was the state requesting standard bond from the council?
An elevated bond due to his priors in Collier County.
Okay. Your Honor, I will ask that the court will consolidate some of the offenses for bond purposes, particularly the intent to deliver for the same alleged controlled substance possession, but there's nothing indicating that it's more than what the personal use is. And I think the court will grant a standard bond or some other release. I did not hear the state indicate whether or not Mr. Escalona has any prior bond felonies. I was not able to hear that. And if he does not, then I will make further argument for release on standard bond or some sort of pre-trial release.
Okay, I've had the opportunity to review, to listen to the arguments of the parties. I'm ordering $2,500 bond on counts 1 through 11. That's $2,500 each of the 11 counts, and $500 on count 12.
Judge, count 1 through 11 is 2,500.
Does that make sense?
I'm just asking, so I can just double checking.
2,500 on each.
Counts 1 through 11, correct?
Yes, ma'am. And then 500 on count 12. 28,000. All right. Don, make
That's a bond.
the bond out, you said?
Yes, ma'am.
Thank you. Tomas Bofnarat.
Yes, sir.
Good morning, sir. You speak, or good afternoon, sir. You speak English?
Good afternoon. Yes.
All right. Thank you. It's great. Any questions for finding probable cause?
Only as to the misdemeanor criminals.
What's your argument?
There's nothing in the arrest affidavit, Your Honor, that indicates that there was property that was damaged by Mr. How do you pronounce Bob? Bob. The Bob.
Dave?
Or the misdemeanor charge is $200, I'm sorry, $200 less, so the amount actually need to be alleged to be arrest warrant to price.
What are they saying? Damaged?
They're saying that the samples that were previously there were no longer there. They're basically alleging that by the damage.
I'm gonna not find no probable cause of criminal mischief count. But I will find probable cause on count 1. State arguments to bond.
Yes, Your Honor. He does not have any prior convictions, so standard is okay. Oh, Your Honor, he also examinations, they're aware that he's placed inside the business. So, given that,
I'm gonna stand by my ruling with no probable causes to count. Defense?
Your Honor, did the pretrial officer say if he is acceptable for the trial interview?
All right. I'm gonna order pretrial services with an alternate bond of 2,500. Alternate bond of 5,000. Thank you. All right. All right, sir. I'm going to require that you stay away from the property. Bring it back. Sorry.
Count 2 is no PC release, all right?
Correct. Sir, I'm gonna order that you stay away from the address 5580 Northwest 107th Avenue, apartment 214. Do you understand my instruction?
Yes.
Your Honor, it's a victim, and that's her address. It would be from Kayla Mendez Marcano.
I'm sorry?
Kayla Mendez Marcano.
Do you know who Kayla Marcano is?
Yes.
All right. You're not allowed to see her, speak to her, have contact with her. Do you understand?
Yes, sir.
All right. I'm gonna stay away from my side. Yeah. All right. Thank you, sir. You're good.
Thanks.
Mr. Tyrese Leon Pratt?
Yes.
Mr. Leon Pratt? Hi, you're right.
Sir, do you speak English?
Yes. This is an ad charge, Judge.
Thank you.
Do you need a do?
Nothing.
No.
If you want.
Do you prefer to have an interpreter so you can understand what the code is?
It's okay. I understand.
Your Honor, I do not have a probable cause.
I'm sorry?
For Mr. Leon Pratt?
Yes.
I do not have a probable cause on.
All right. So I'll find probable cause on this case. State as respond.
Your Honor, he has open resisting without violence. We would be asking for a elevated bond.
Defense?
Your Honor, the standard bond set. I don't have to require, Your Honor, for Mr. And I'm sorry, Your Honor, I think it's the wrong fire was attached.
I think the issue is that he was in custody on or assisting without violence and then commits a battery. He was alleged to have committed a battery by a detainee. I'm gonna order $5,000. Fine, from.
I don't think he's a bond.
I'm sorry, I couldn't hear Ms. Gray. Is there further argument?
Mr. Pratt was just saying he did not think that his mom would pay the bond.
That he was?
That his mother would not be able to pay the bond.
You may be able to address that with another judge, sir, but based on based on the facts here and that this is an added charge, I do have to consider that, okay? So that'll be the bond amount. Sir. Then I have Robert Boatwright.
Judge, Mr. Boatwright is out on probation F-22-008110.
You?
Your Honor, we're waiting on the Mr. Boatwright. Oh, Your Honor, corrections advises that there are no other cases here. Hey, yeah, we're still in. Your Honor, Mr. Boatwright is not here.
He's not there?
Correct. They don't have any person.
So this is gonna get reset? Or do you want to wait for his presence to take a look at the form?
Mine can't be expressed without the okay and be expressed.
All right. We're gonna reset this to tomorrow.
Reset tomorrow, Judge?
Ma'am. And then we have Mickinson Magnan.
Your Honor, he is also not here. The correction says that we have no other persons.
Oh, Judge, he was relocated to Metro West. Reset to tomorrow.
All right, set at 12:14. And all right, I believe that completes our calendar. Thank you all very much for your hard work, for staying so late. The court appreciates it.
You have a good afternoon.
Ms. Gray, will you be with us tomorrow?
Recording stopped.
I may possibly, Your Honor.
All right, if not, you'll take notes for the arguments that the court wants guidance on?
Yes, I think that there's only one reason for the argument. That was the, but you'll ask the ASA.
I'm sorry?
I'm asking that the assistant state attorney, if they can send the copy of the motion for pretrial detention.
Yes, I have indicated that they're required to do so. They'll send it to you by email today.
Ms. Gray, could you please tell me your full name so that I can find you?
Let's go off the record. All right, we're off the record. Ms. Gray, email address.
You can send it to T as in Tamara, GRAY at pdmiami.com.
All right, thank you, everyone. Have a good afternoon.
Thank you.